Lord's kind leave, my lord. There's one matter of some urgency. There is, my lord, land in Hubli, Dharwad of about 1 acre of land, which was kept for a reservoir. That is being allotted by the government, my lord, at 5% of the guidance value to a political party, the ruling party.
Fresh one.
Beg your pardon?
Fresh matter.
It's a fresh matter. And, my lord, a government order has been passed to allot that 1 acre of land at 5% of the guidance value, contrary, my lord, to the resolution of the Hubli Dharwad Municipal Corporation.
Next week.
Lordship, I think they'll execute a sale deed, my lord, in favor of the Congress, in favor of the party.
Pardon?
They are likely to execute a sale deed in favor of the party.
Day after.
Can it be tomorrow then? Because if they execute a sale deed, then everything will have to be undone.
PIL.
It's a PIL. Tomorrow. I'm grateful.
My lord, fresh matter, contempt, civil contempt, my lord. Urgency is for the Tahsildar is not complying the order passed by the writer.
Will come on 3rd April.
My lord, serial number 4, senior is not keeping well.
My lord, serial number 20, my lord, may I request for
20.
please, my lord.
Request.
3 weeks, my lord, may.
After.
Please, my lord.
Send over to 6 June.
Much okay.
Serial number 4, my lord.
Moving IE. Day after.
Serial number 44.
Serial number 48 for the respondent.
48.
48. I will intimate the company.
2 time. 1 time.
Yes.
Can it go after vacation?
But I will intimate the other side. I will take 2 weeks time.
2 days will not be.
2 weeks time.
22nd of April.
Okay. My lord. My lord. Serial number 4, my lord. Appearing for petitioners, senior is not keeping well. Kindly accommodate short treatment.
No.
Lordship, serial number,
You be here when it is called up.
Lordship, serial number 34, Lordship. I pray for time, Your Lordship.
Lord, serial number 34.
I'm appealing for appealing. I've informed the other side also. Other side
Serial
is-
number 34, the order of the not appear for respondent. It's only for withdrawal, notes. The institution has given them instructions to
No,
withdraw
no.
it.
It is not for.
The order of the land
still,
thing-
I have to get the instruction, Lordship. That's why I'm seeking time.
It's
Lordship.
already communicated to advocate, but he
No,
wants
no.
in writing.
So not communicated. So day after tomorrow at 2:30.
No, they have, after 2 weeks it may be given.
No. For withdrawal.
Next week at least, next week. It's
Second-
not for the withdrawal.
Promotion
I
is
have to
withheld.
just get the
My
instruction.
promotion withheld only on the
2nd
ground.
April at 2:30. Since it is for withdrawal.
No.
Not it's for withdrawal, my lord.
It's not for the, I have to still get the instruction, Lordship.
That's
Regarding
already-
that, I have to get the
Institution has
instruction.
already
That's why I'm
communicated them.
seeking 2 weeks time, Lordship.
Then, no, 2 weeks will not grant.
1 week may be granted.
1 week, 2nd April.
Please.
Serial number 44, my lords, in this.
Yes, Mr.
My lordship, I am kindly moving a memo for hearing on application for recalling, my lordship. Public interest.
Recall can go to 21st April.
My lordship, kindly a short date because sand mining is going in very high. It's a matter related to sand mining. It's going in very huge.
15th April.
My lordship.
44, my lords, in this.
44, my lord.
I'm for the respondent number 11, my lord. My name is not shown in the,
44, my lord.
Yes.
my lords. I'm for the respondent number 11, my lord. That's in this. My name is not shown in that. That is the reason, my lord. My name is not shown.
Name, what is
Respondent number, I filed a wakalat on
Is it about-
22/2/20.
What is the subject matter? PIL, we know that. What is subject matter?
Subject matter, my lord. In this, the advocate himself has then drafted the GPA and tail deed is concerned, my lord. There was a litigation, criminal litigation is pending, my lords.
No time, yes. No, time when it is considered, we'll see.
Serial number 31, my lord.
The name is not
Yes.
4th April. 4th April.
Serial number 31, my lord.
Yes,
Your Lordship, this is an review petition.
Serial number 49, my lord. I am the
49.
Respondent. Serial number 49, I am
Yes.
the respondent.
yes,
Expected the other side, my lord. To file objections 2 weeks time.
23rd April.
Serial number 25, my lord.
Your Lordship, this is an review petition, Your Lordship, in this matter. 21 to, yes, Your Lordship. 21 to 2024, 5, Your Lordship, is listed and date was not given, Your Lordship. In this matter, urgency, Your Lordship, academic year also ending, Your Lordship. That's the reason some urgency. Kindly have it on,
Review before which bench?
Your Lordship, same bench, Your Lordship.
And 21st April.
Your Lordship. 1 month already lapsed.
And all matter cannot be taken, Mr. 9th April.
Please, Your Lordship.
Serial number 25, my lord.
Yes.
Serial.
Appear for the respondent, senior is not in station. I inform the petitioner.
I appear for the appellant, my lords.
After, it will go after.
My lords, I
Yeah.
appear for the appellant. I'm pressing for an interim order, short date may be granted, my lord.
Then there is no consent.
My lords, I object for the adjournment, my lords, but 58.
Then there. Let it be called out, we'll see.
Serial number 25, my lord.
31, I am appearing for the appellant, my lord.
30, 31,
31, my.
yes,
I am for the appellant, my lord. May I seek some accommodation, my lord.
12th of June, as requested.
Serial number 25, my lord. Serial number
16, my lord.
16,
Please, my lord, there is some inconvenience. I appear for the appellant. Request for 3 weeks.
when do you want? After
Please.
17th,
Serial number
June,
25.
as requested,
Let's wait.
Serial number 25, my lord. 6 time, my lord.
25.
Petitioner,
Yes, what do you want?
6 my time. 6 my time. Senior inconvenience.
What do you want?
47, my lord.
47, 8th of June,
Before I question.
before vacation. 17th of April.
Serial number 42, my lord. I appear for the petitioner. Some inconvenience. to them.
Yes, Mr.
15, my lord.
15,
When they take around 17, I have informed the police.
17th, 17th.
No, for respondent number 4, my lord. My wakalat may be taken on record, my lord. Voluntarily.
File it will be taken, file in registry, yes.
Yes, 17.
17th they want. They want 17th April. Pardon? What is it?
I'll file application for stay.
Pending you don't, if you don't agree, then we'll not grant time. Short notice. Earliest view. Yes, Mr.
Serial number 42, my lord. I appear for the petitioner. There's some inconvenience today, my lord. I have it in April, any date in.
24th April,
Great.
24th.
Great.
Your Honor, for WA 983 of 2024, I request the orders for Form C reinstating Form C and the WA be listed in the appropriate court for tomorrow. The urgency is that the respondent will provide the status about the consent letter to the Honorable Court once it is listed. And the urgency is there to initiate the original suit and receive the interim relief orders.
You go before the court concerned where we have to mention there. Not
You-
our- It doesn't belong to this court, Mr.
I
Party.
have a memo for posting.
Not before this court, before the court concern. Wherever it is like going to be posted, as per roster, you mentioned there.
Okay,
We
so
can't post the. matters of-
the last time the orders were issued by Justice K.S. Mudgal in CH-5, should I
We
appear
do
there?
not know. We do not know. Go to the,
If the issue was related to Form C, Your Honor.
that also we do not know. You go to the registry and find out to which court it belongs and then mention there.
I request a file be brought in here today so that I'm heard.
It can't be brought like that. Only before the court which is taking up the matter as per the law.
The registry says that I'll have to meet you and have filed the.
Registry may say anything. What is procedure is procedure. It can't be mentioned here, Mr. Like matter which is belonging to other court as per roster.
Your Honor, the respondent can provide the status of the consent letter only when the writ appeal is listed.
Get it listed before the appropriate court.
It will be listed.
We do not know. You go before the court concern and request.
Okay, the question was about the Form C, Your Honor.
We also do not know unless we know only if matter belongs to this.
Then upon your request, I'll, upon your direction, I will approach the direction from the court, Your Honor.
Listed before the appropriate court as per the roster.
Okay.
Right? Yes. Yes, Mr. Yes, Mr.
Serial number 25.
20?
Adjournment. 25, my lord.
What do you want?
Serial number 25, my lord. 36, adjournment. Senior personal inconvenience.
Somebody objected?
I'm
No.
petitioner. I'm petitioner, sir. Petitioner, sir.
When shall we keep? 21st of April? 21st April?
Oh, what?
All. Yes, madam.
With your lordship's guidance. My lord, it starts from 73. There are batch matters with regard to the international workers challenging the para 83, my lords. In few cases, notice even though was served, the company stands there only, but it has been somehow or whether it says it's not served. So
Employees,
may I request your lordships to have this matter after 20th, any day convenient to the court. And then these matters, in all these matters, wherever notice has not been served, may I request your lordships to give hand summons to the companies only because they are not individuals. They are companies, they're only working, but second time, third time, fourth time, we are taking third time now. So
we have to find out in which matter the notices are not. So
I'll give the list.
Notice renewal after vacation or this second?
Time already, it is very urgent. That is the
Very
reason I have. No, any day convenient to the court because unless I serve, the cost list shows it has not been served or not received
Don't
second
worry.
time, third time. That is the reason.
29th April.
Little early, my lord, if possible. If possible, otherwise I won't trouble your lordship because it's on the last day.
22nd April.
22nd, very well. And I will give the list to the court officer.
That is better. You go to learn a court officer as well as to learn a stenograph. Both. Or you pass over. Wherever it is that notice written.
Yes, my lord. So that will take hand summons.
Deliveries. Service
Yes.
by hand summons is perfect.
Hand summons to the all the non-certain. Much obliged. Court petitions.
Serial number 63, my lord, contempt matter.
60.
Contempt matter may be closed, my lord. They have complied with
63.
63.
You are for petitioner.
Complainant.
Learned advocate Mr. Mohan Kumar. He stated that the order brought under this contempt proceeding is complied with. Therefore, the proceeding does not survive. There are any statement made by learned advocate to the petitioner. This contempt petition is dismissed as not surviving.
But serial number 98, my non-compliance. At a 4 weeks time, may kindly be granted for this reason, but the petitioner herein has filed review petition before the single, but we are unable to 98 for office objection compliance.
92.
98.
4 weeks time is granted to remove the office of justice, telling which the appeal shall stand dismissed for want of prosecution automatically. Shall dismiss automatically without reference to order of the court. And similar order is 93 and 94, 4 weeks. And similar order in 95, you grant 3 weeks. And similar order on 96, 97, 98, you 2 weeks, same order.
Any other submission through EC, sir?
Serial number 93 and 94, my lords. My lord, there was an order
It is
passed.
already granted.
My lord, there was an arrangement was on the previous date, my lord, may I request for the same interim arrangement to continue, my lords.
Not audible, madam.
My lord, serial number 93 and 94, my lords.
You are not audible.
Uh,
It
My
is
lord,
time
there was,
already time is already granted, 93 and 94.
my lord, there was an interim arrangement on the last date, my lords. May I request for the interim arrangement to be extended, my lords?
Interim leave extended, 90. Interim leave case, how can there be interim leave when there is an office objection?
My lords, the office objection was with a counsel submission, my lords. The office had raised an objection on the prayer that is sought by us, my lords. May I request for the matter to be taken up when it reaches, my lords?
Okay. Accordingly, order. Complex time. Please, see. How this can become to be listed under office of to comply with office of
Oblige, my lords. My lords, ma
92 and 93 give to only 1 week time. So the interim is operating. Yes. Next.
Then permission, the contempt matter is seal number 1. Mr. Balanikit.
Petitioners, your lordship. Lordship, this is an contempt petition filed in view of non-compliance of the order of the Honorable Court in WP number 95/2017. Your lordships, the respondents in this particular contempt petition have assailed the order and have preferred a writ appeal can be taken together.
16 June as in view that the rate appeal is coming up on 11 June.
11/6 is the date it's coming up. Your lordship. The writ appeal is coming on the 11th of June.
Seal number 2. Mr. Kar.
If a shorter date may be granted.
Seal number 3.
Appearing the complainant in this matter, not liberty to pursue the matter before the family court. Bank.
Learned advocate Mr. So-and-so files memo. Ticket so-and-so, form of your breach is served. To learn advocate so-and-so, respondent. Whereby prayer is made before the court to permit withdrawal of the present complaint. Seeking remedies under the Guardians and Wards Act 1990. Permission is granted, present. Contempt petition is this legal remedies which may be available to the petitioner. Petitioner is liberty to pursue all legal remedies which may be available to him. In respect to which, however, this court does not exercise any opinion.
Grateful, madam.
Shivraju.
We are also great. We are more great.
For petitioner, my lord.
Yes. Yes, for PIL. That's is the one you wanted time.
Petitioner,
What is the problem?
my son is kind, is not keeping well, my lord. Any date may be accommodated.
The 2 acres of land has been reserved for solid waste management plan.
Machine is not keeping well. Much of it.
April.
21st of notice written on 20. You want notice or don't do?
My lord,
You want notice?
notice is issued already, my lord.
Already issued.
No, in last 33-76, the notice is issued to respondents, my lord.
What is to be done? You want notice? In this, you want notice or not?
I want, man. I will say, my lord, but issue is different.
Issue is different,
Not different, but we have to adjudicate it.
but notice is different.
Hello?
Notice is also different.
Yeah, my lord.
Really, next.
Still number 6.
You are accepting not?
No, my lord, in that I have sought for instruction. This also I'll see. This number 6. My lord, this and serial number 69. My lord, I pray for some time, my lord. I'll file my statement.
My lord, this is the matter where the bar association is before the honorable court, praying that there should be proper
defects.
software, my lord, for registration of the deeds of conveyance. Now, Kaveri 2.0 doesn't answer the law at all. It's totally inconsistent with the prevailing law. And today I'm told, my lords, the software has crashed. And since several days, advocates are not able to work on this software.
Every problem we are not solving.
That's true. But the state should come out with the lawful solution where, my lord, registration is not stopped and advocates are able to give proper advice and
Lord,
get
in
the
the
deeds of.
connected one statement have been filed, my lord. In this, I just want to look into the problems, my lord, that they have put forth by way of the representation and see how it can be solved, since it pertains only to Mangalore, not to the other
No,
states.
this software Kaveri 2.0 is a state
Yes,
phenomenon,
but
my
it
lord.
was sought for only
Kindly-
Bangalore.
Kindly see page number 50.
They are better judge than the court as far as this subject is concerned.
Please, my lords.
So,
And my lords,
naturally.
I am informed that the concerned minister has also conducted a meeting. Nothing happened about 6 months ago. Then the Vidhan Sabha, my lord, they gave it's not been rectified. So my solution is, till it's rectified, my lords, let them revert back to Kaveri 1.0, which has already been there. They cannot come with the defective software, my lords, put the people and the advocates into sufferance.
They will find out somewhere.
Yes, my lord.
Now, your lords may kindly see, my lords, my lord, and friend put it that it's a Mangalore phenomenon. No, in Mangalore, of course, they have not integrated, my lord, with the record of rights. My lord, Isottu has not been integrated. Therefore, registration cannot happen. There are about 25 points we have mentioned in page number 50 in the representation, my lords.
We are not going to interpose ourselves. This is only because the
Please, no, my lords, my only prayer is,
Bar Association is here and some
please,
issues are concerned, we are asking them.
May I pray, my lord, let them have a time-bound manner in which they
Nothing.
have a,
Entire rule is in their code, and they will take code. That is exactly only
please, my lord, it actually not only concerns the advocates, but the
find out in what way they are.
public also.
Suggest some constructive ways to.
My lord, we can see how best to resolve it. Just to
My lord,
work.
every person has a right to convey his title to a property, my immovable property. It has to be registered in the registration office. Now, what they have done is they come out with a software. So, absolutely no problem. The software must be workable, number one. It should be workable in tune with the law, in tune with the concerned provisions, my lords. This software doesn't allow registrations as per the Registration Act, as per the Transfer Property Act. A software cannot be a way to amend the law, have a new law. Software cannot be a law unto itself, my lords. Now, this is the exact problem here. Now, the software does not permit the registration of documents as per law. And they say, my lords, e-sottu, that's the revenue records are already documented in the e-portal, they say. It is not.
You want them to consider or not?
Please, my lords. But till then, your lords may kindly have a direct us to have a solution, my lord. Till then, for example, till then, please, my lord, some solution, your lords may kindly permit us, my lords.
You disclose our mind, but still you want, then we'll pass.
No. I want a solution from my lord's hands in this case, my lords.
Today, now choice is yours. You want them to consider, or you want us to consider?
I want them to assist the honorable court
Then let it.
properly, my lords.
Otherwise, we are.
I know, my lord, because unless the state assists, my lords, may not be able to have a proper software, but we are ready to assist. May I suggest this, my lords? The advocates body, my lords, we want 2 or 3 experts, my lord, to assist them, my lords. In the software glitches, wherever it is there, my lords.
To suggest the expert, they will account.
Yes,
We
my
will.
lord.
We will 3 advocates from the bar, my lords. We will suggest to them, my lords. We will put the names to the my learned friend, my lords, so they can sit together. Please, my lords.
So dispose of on that line.
No, my lords, it's an interim measure, my lords. They have to come to the proper solution. Please, my lord. Would I take this suggestion, my lords, that they will accept it, at least 3 names so that they proceed ahead. We are at the process of facilitation of. I understood, my lords.
Because it will not come back.
No. I want my lords to give justice as far as this.
So we are trying to do that within our bounds and jurisdiction.
Please.
When shall we?
My lord, the 3rd week of April, my lord.
23rd April.
Obliged.
Please, my lords. Grateful.
This is number 7, Mr. Samir SN.
My lord, on 6/9/2024 and 7/9/2024, on the occasion of the Ganesha festival, there was a holiday, and one Marsuru Krishnappa, he is from.
What is the problem?
He has erected illegally statue of, that means he has kept a statue of POP material in a school, in the higher primary school at Chintamani, without any authorization. Where the Honorable Supreme Court at Annexure J, page number 84, my lord, has clearly held that no statue shall be erected in the public places, public premises or public places.
What public place?
Order at page number 85.
What is that?
My lord, the Honorable Supreme Court in SLP number 8519 of 2006 as clearly said, until further orders, we read we direct that the status quo as obtaining today shall be maintained in all respects by all concerned with regard to Triangle Island, where a statue of the late Sri N. Sundaran Nadar has been permitted to be sanctioned. We further direct that henceforth the state one shall not grant any permission for installation of any statue or construction of any structure in public roads, payments, sideways, and other public utility places. Obviously, this order shall apply to installation of high-mast lights. Streets shall not apply to installation of high-mast lights, street lights, or construction relating to electrification, traffic toll, or for development and beautification of the streets, highways, roads, etc., and relating to public utility and facilities. Based on this order, this honorable court in WP number 4960 of 2017, the PIL also held the same, where in this case, a statue of Srikanta Todayar was about to erected in the Mysuru Mahanagarpalika limits.
The statue at which place?
Mala?
Statue is at which place?
Mala?
Statue is at which place? The statue
Yes.
is at which place?
Yeah, it is just place, my lord. It is material POP. Now, by the act of
At which place it is?
it is
Not
school
in a
premises, higher primary school, government school, Chintamani. The government has also issued a circular dated 17/12/2012 in this aspect, and also another circular on 23/12/2019. In this aspect, FIR is also filed against the person who placed the statue. 3 FIRs has been filed. Block education officer, BEO. Immediately on the next day itself, a complaint has been lodged by the headmistress.
My lord, I make one submission. My lord, the person who has mischievously installed this hasn't been made a party. My lord, but the government, my lord, the headmistress, the block education officer, my lord, they have all initiated action. My lord, the direction of the Supreme Court was that no permission should be granted for installation of such statute. My lord, that order, my lord, gets it at Annexure J. My lord, yes, at Annexure K. My lord, paragraph 4. It is not that, my lord, the government has given permission. Now, my lord, illegally it has been installed. Paragraph 4, my lord will get the second sentence. We further direct that henceforth the state government shall not. We haven't given any permission. My lord, and I am informed that in the recent rains, my lord, that happened on Friday and Saturday, my lord, the statue has melted because it is made of plaster of Paris. Yes, yes.
Yesterday the statue has been melted.
No, and not the height.
Then once again they will keep that. My lord, now, no, statue is there. See, this is the thing. Yesterday it has happened.
Plaster of Paris.
Yesterday, due to rain, a branch has fell into then the persons are protesting day by day, and they are also protesting the Freedom Park in Bangalore also by coming walk jata. Once again they will keep it, man. Once again the authorities has to take action, and the law, my lord,
My lord, the government families. My lord, if my lord were to grant us.
my lord, my lord, my lord, a small submission. Placing such POP material statues in that public place, now it has been melted. This is an insult made to an honorable person, by the act of that a mischievous person. Yes, my lord. No, my lord. The law is very clear. No such statues can be erected. If they have to erect it, they have to get a permission, and they have to give an undertaking that they will maintain. They will maintain. One organization or any person shall maintain that one properly. They have to give an undertaking, and then only they have to get permission, my lord. From the school, my lord. From the school, within 50 meters, there is an Ambedkar Bhavan, and there is a big bronze Ambedkar statue. Well, but due to protests, the school, the education has been, some wrong message has been passed to. No, from the within 50 meters, there is a big bronze statue. Yes, it is metal.
Yes, that's what he submitted. Yes.
Further statutes may not be installed in future without permission.
My lord, the melting of the statue was stated by the petitioner's counsel.
I placed the photographs. I placed the photographs before the sunroof.
Yes, yes.
I passed the photographs, man.
Yes, my lord. Then I wouldn't know.
The Greenway matter, seal number 8, Mohammad Rizwan.
Respondents. But I had filed my statement of objections, my lord. They have filed rejoinder enclosing 10 documents, my lord.
May I please, Your Lordship, my lord. But the petitioner before Your Lordship is my lord Kudremuka Ernor Company, which is a mini Ratna company of central government, my lord. It was granted a mining lease, my lord, and registered on 18/1/2023 over 401 hectares of Devadari village, reserve forest area of Kumaraswamy range, my lord. After all the statutory clearances, the government of Karnataka issued G1 dated 11/4/2023. Your Lordship will find it page 20, Annex A.
I'm not aware, my lord, if there's any identical here, my lord. They have actually complied with stage 1. my lord. Now we are required to hand over the lands and then compliance with stage 2 will arise, my lord. Now I have filed my statement of objections. I have produced documents to show.
They admit, my lord, in the statement of objections, sorry to interrupt my learned friend, they admit in the statement of objections, paras 5 and 6, categorically state, I have complied with all the conditions, and stage 2, para A I completed, para B I have to comply with after they hand over the land to me. Now the question is whether egg is first or hen is first. Now Government of India says, you deliver the land to them, land to the government company. Thereafter, part B, after handing over of the site, I have to comply with certain conditions. I am not shirking to comply with the conditions. I will comply with, I give an undertaking, Your Lordship may pass a judicial order in supplementing the Government of India's directions. Government of Karnataka issued, kindly see page 19, Annex A. Government of Karnataka says, they issued the GO. Now, only thing is, certain haunting expression seems to be allergic.
Lord, I have filed my statement of objections, Lord. Conditions, they have fulfilled stage 1 condition. We do not dispute that fact, Lord. We are now required to hand over the lands, Lord. Now to them, Lord, which is about 400 hectares of virgin forest lands, Lord. Now I have in my statement of objections, 400 hectares of forest, Lord. For mining,
Now, I have produced documents along with my statement of objections to show how past violations in respect of the earlier mining lease have not been fulfilled, my lord. If Lordship kindly takes for a moment, the earlier order, now, my lord, they are, kindly see annexure R3 at page 60, my lord. My statement of defense, my lord, defense is that I have lost confidence in them because they have scant respect to the orders of the Honorable Supreme Court. Page 60 may be seen annexure R3, my lord. Their mining operation was stopped as on 31st of December 2005 by the order of the Honorable Supreme Court. The mining area was declared as Kudremukh National Park. Now, subsequent to the closure of mine, this is a different land, my lord.
So then how can you connect?
Lord, I'm connecting. The reason is they were required to perform they were required to comply with the directions issued by the Honorable Supreme Court. Hand over about 114 acres of land. On account of their illegal raising of the height of the dam, there is a submergence of nearly 465 hectares of land. They were required to apply for post facto approval under Section 2 of the FC Act, which has not been done, despite the direction of the CEC. So therefore, my stand before your lordship in the statement of objection is, until and unless they comply with those conditions, my lord. Now, once I hand over these lands, my lord, it's an irreversible position that I land myself in.
But the compliance is in respect of different land.
Yes, my lord. But the fact remains that they have not shown any inclination to comply with those conditions itself. For a moment, my lord, may I request your lordship to kindly take annexure R3, my lord. They are duty bound. Annexure R3, page 60. This is the report of the Central Empowered Committee. Page 62 may be seen. Page 62 may be seen. Transfer of buildings and land. After the site visit of KOICL, mine area so-and-so, a joint report on the status of the building in Kudremukh was prepared by team consisting of officials from Forest Revenue so-and-so. As per this report, there are 493 buildings with 1617 quarters on revenue land and 579 buildings with so-and-so in KOC own land. These buildings, along with revenue land measuring 122 hectares and 114.7 hectares of KOCL land, are required to be handed over at book value to the State Forest Department. This has not been complied with. They have not handed over 114 hectares of land in their possession with buildings to the state government. This is one such violation which I want to highlight, my lord. The second aspect is, my lord, kindly see the para 6. CEC, after considering pleadings of the KOICL with regard to non-forest use of forest land, is of the view 340 hectares of forest land involved in Lakya Dam water spread area as per the guidelines under FC Act would require clearance under the Forest Act 1980. KOICL was asked by the CEC to immediately vacate the revenue land occupied by them in compliance with the order so and so. Now, what happened, my lord? On account of this illegal raising of the dam height, my lord, which your lordship will get it at annexure R5 at page 79 may be seen. Page 79. Lordship will see the very first para. With regard to the above subject, so and so, KICL has illegally utilized 465.73 hectares of forest lands, which are detailed below. One is on account of submergence of the forest lands, on account of illegal raising of the dam height, my lord. Then laying of pipelines contrary to the forest laws. Illegally, these pipelines have been laid. Then illegal roads have been constructed. And mine expansion after lapse of lease, my lord. So in all, 465 hectares of land was required to be, post facto approval was required to be taken under Section 2 of the FC Act, my lord. Now what they do, my lord, they apply for a partial approval of only about 335.82 hectares. They do not apply for 465 hectares, my lord. They keep this approval pending. It is going to and fro. The central government has called upon them to say, please apply for the entire extent. They do not. Now, if they apply for this post facto approval, my lord, then this land will have to now be made available to us. NPV value has to be paid by them. So therefore, my lord, all I am saying is past violations are not being regularized. And if I hand over this land to them, my lord, I have no confidence that they will also comply with the conditions post handing over of the forest lands. Today, I'm in a position to save this lands, my lord. They must demonstrate by conduct that they have applied for this entire extent of land. Payment has to be made to me. They have no intention to comply with the orders. Why should I hand over the virgin forest lands to them, my lord? I'm at a stage where I can take a decision not to hand over to them, my lord.
May I submit, my lord?
So this condition number 8 is acted.
Condition is fulfilled, my lord. I'm not disputing that fact at all. Stage 1 condition is fulfilled. I now have to give the land to them, and then stage 2 condition.
That violation remedy will be separate.
Lord, they will not comply at all, my lord. Despite direction of the Honorable Supreme Court and the CEC, they are not complying. Then how will I enforce stage 2 conditions, my lord? I'm at a stage where I can ask them to comply and take the possession of the land. We are not denying it, my lord. But they are required to apply at least for the permission under the FC2, my lord. Let them comply with all of these directions, my lord. And then I'm willing to hand over the land to them.
Your forest.
Land, virgin forest lands, my lord. This
Your forest authority.
forest, yes, my
Or
lord.
state.
State, my lord.
Your state.
State.
May I submit, my lord?
Stand of the
My
state.
lord, all the submissions made by learned friend were considered by the highest authority called Forest Advisory Committee, Government of India, Ministry of Environment and Forest. It issued the proceedings on 16th December 2022. Kindly see page 58, my lord. Kindly see page 58, annexure F of my petition. Writ petition. All were considered.
No, he's pointing out to this document to which I'm not disputing. This annexure E conditions have been fulfilled with, my lord. I'm not
No,
disputing.
I'll be
the
grateful to your
conditions.
lordship, my lord. At
I'm
least
only
let.
saying his past violations.
I'll
with
be grateful
regard
to your
the-
lordship, my lord. At least I may permitted to read heading of para B of page 59. Kindly see page 59, para B heading only I will read.
Page 59.
Page 59, my lord, of my writ petition. 58, the proceeding starts, my lord. Para 59, condition, para heading B. Conditions which need to be complied with after handing over a forest land to the user agency by the state government. Now my friend is complaining that I have not complied with para B, which I humbly submit. I have to comply with after they hand over the land to me. This is the decision of Government of India. This order is not challenged. On the other hand, my lord, the government issued a consequential GO. Annexure A, your lordship may kindly see. The government of Karnataka issued a consequential GO on 11/4/2023, Annexure A, page 20. I am seeking implementation of the GO issued by them. Their own GO says, para A, conditions which need to be complied with. They admit para A conditions are already complied with. Para B, conditions which need to be complied with after handing over of the forest land to the user agency. Now the government is not handing over the land. And they wanted to twist, because your lordship may kindly appreciate, the old mining lease was granted prior to the commencement of Forest Conservation Act. That is an old lease of 50-year-old back, my lord. And certain violations which they recognize, and those violations, my regularization, the entire scheme is there, how it is to be regularized. That is to be complied with by me after they hand over the land. Their own GO, the apex body of the Forest Conservation Act, FAC proceedings also says, once they hand over the land to me, then thereafter my obligation to fulfilling will come. Now they want, since this is not complied with, we have an apprehension that the central PSC will not comply with.
Has also granted. Lordship may kindly take the defense of the state in 4 paras of the statement of objections, my lord. Para 8 may be seen on the statement of objections. Para 8 to 11 is our defense of the state. May I just read it out? Para 8 of my statement of objections. It is submitted state government in view of the flagrant violation of the order, directions of the Honorable Supreme Court and recommendation of the CEC by the petitioner company. Para 8 of my statement of objections. Para 8 to 11 is the defense of the state. It is submitted that the state government, in view of flagrant violation of the orders, directions of the Honorable Supreme Court and recommendations of the CEC by petitioner company, is contemplating whether the reserve forest land in Ballari, which is still pristine and virgin, should be handed over to the petitioner company, since the state government is not confident that petitioner company will comply with stage 2 conditions. Para 9. It is submitted its petitioner's own conduct which has created this apprehension in the mind of the state government. Thus, petitioner, in order to seek for release of reserve land situated in Ballari, should firstly comply with directions of the Honorable Supreme Court by applying for post facto approval of the balance area under the FC Act in 1980, transfer buildings and other infrastructures at book value, hand over ownership of land to the extent of 114.3 hectares, and it is only on compliance of that petitioners are entitled to seek for the present relief. It is submitted respondents herein have been repeatedly requesting petitioners to company to comply with all violations. However, petitioner company has failed to comply the regularization of violations. 11, my lord, it is submitted stage 2 conditions also disclose petitioner company is required to regularize all violation, if any, in accordance with the directions of the Honorable Supreme Court and recommendation of the CEC. The manner in which petitioner company have not even addressed, that's all. That Supreme Court order, Lordship will get it at page annexure R1 at page 15, my lord. The earlier mining operations in 4000,
15.
Page 15, annexure R1.
What
is
does
the
it say?
order of the Honorable Supreme Court. Lord. Relevant will be at page 21. Page 21. Middle of the paragraph, page 21. Middle para. It was noted that Kudremukh National Park, Lordship got it, no? In which mining activities were being carried out, was declared to be national park in terms of section 35(1) of the Act. The matter was referred to the CEC, constituted under section 3 of the Environmental Protection Act. After hearing the parties and taking note of the material placed before it, committee has recommended as follows. After carefully considering all views and suggestions, the exceedingly rich biodiversity of area, investment made by QICL, suggestions were made by learned amicus curiae, committees of the view QICL be asked to wind up its operation within a period of 5 years or on the exhaustion of oxidized, whether secondary ore, which is earlier. In already broken up area, it is clarified, period of 5 years would commence from 25/7/1999 when its lease has expired. Now, in pursuant to this, my lord, QICL has wound up its mining operation on 31st of December 2005. Now, kindly see, my lord, the winding up period of 5 years shall be subject to following conditions. Now, Lordship will see at page 22, condition number 5 has not been complied by them. After winding up operations are complete, QICL will transfer all building and other infrastructure to Forest Department of State of Karnataka at book value. This is despite 1999, my lord, 17 years have passed. They have not transferred these buildings or 11.4 hectares of land, Lord. Kindly see, my lord, the central CEC at page R3, at page 60, my lord, in its report, page 60 R3, my lord, which relevant page at 62, which I just read out, my lord, where they are required to transfer the lands, apply for post facto, page 62, my lord. They increase the height of the dam, my lord, tailing dam, on account of which, page 62, my lord.
Yes.
Because of the illegal raising of the height of the dam, my lord, 340 hectares of forest land got submerged, my lord. They are required to take a approval under section 2 of the FC Act. It's a post facto approval, which your lordship will see at point number 6, my lord, of the CEC, which has not been complied with till date. They apply, kindly see annexure R4 at page 63, my lord. This is the application dated 10th of March 23. They apply only for partial land. They do not even apply for the entire extent of land. If this is the conduct of the petitioner in complying with the directions of the Honorable Supreme Court, we have now taken a stand that we don't have confidence in them. Whether they will comply with stage 2 condition itself is in doubt.
Mr. Pitman. My learned friend is reading about 2002 proceedings of the Honorable Supreme Court of India. Much water has flown thereafter. CEC took over and submitted the report. And it is true, my lord, and we have filed along with our rejoinder that now that my friend has raised 114 acres of buildings and was not handed over, the proceedings dated 5/2/2024, under which, my lord, this handing over was given by Kudremukh to the government. And regarding the Kenya Dam also, my lord, by proceedings dated November 20, 1993, permission was taken to increase the, like this, my lord, on facts relating to para B, which I have to satisfy them after they hand over the site. There are documents, my lord, which we have filed along with our rejoinder. So it is not correct to say that they have not taken any action. They are taking action. We have to pay some money to them as NPV, etc. Money will be paid. My lord, Government of India is completely conscious about the situation, my lord. A running mine which was granted about 50 years back, that is prior to Forest Conservation Act, was asked to be closed down because of environmental angle.
Government is a party. Government of India is a party.
Government of India.
Mr. SR Dodwat.
Yes. Fourth respondent. Is here. First part of condition is complied. That your lordship will, at annexure E, my lord, at page 52 of the writ petition. Page 52, my lord. Lordship will get A, conditions, bottom, my lord. Conditions which need to be complied prior to the handing over of forest land by the State Forest Department, and compliance is to be submitted prior to stage 2 approval. Now this has been complied with. Stage 2, your lordship will get it at page 55.
58.
55, annexure E, my lord. Page 55, my lord. Conditions which need to be complied on field. Page 55, my lord. Stage 2 approval. This is post handing over of the land to them, my lord. We are at this stage now, my lord. We are at a stage where I am now required to give them the hand, and I am not insisting that this condition should be performed by them before I hand over the land. All that I am saying is their conduct in non-compliance of the earlier violations, despite an order of the Honorable Supreme Court. We have lost confidence in them. We are at a stage where 800 acres of land, pristine, virgin forest lands, have to be handed over to them. If they do not evoke confidence of the state, my lord, in performance of these conditions, we are still at a stage. We have considered they had ample time to perform all the conditions by then, my lord. They should have demonstrated by their conduct, yes, we are law abiding, we will perform all the conditions imposed by the Honorable Supreme Court. That is not their conduct. They do not hand over 114 hectares of land. They do not regularize the illegal, on account of their act of illegal raising of the height of the dam, resulted in losing of about 800 acres of forest lands. They are required to apply under section 2. They have not done it.
But it is surprising, my lord, despite in the rejoinder, I filed the documents to show that 114 acres was given to them. Dam was raised because of the approval given by them. But only one question for my lord. 11/4/2023 was the GO issued by the government. This writ petition is filed only to seeking implementation of GO issued by them. What is the change of circumstances? How they lost confidence in me after 11/4/2023 till today?
Lord, my only request is, my lord, maybe some time may be given to them to comply, my lord, because my stand is that I'm willing to give, provided, because we are at a stage where I can preserve the land, my lord. It becomes irreversible once they start exploiting the land. Let them show their bona fides, rectify.
And I pray your lordships to pass a judicial order by this honorable court. Handing over of the land is subject to fulfillment of the conditions as contained in stage 2 para B. In default, the land may be taken back by them.
No, once they start exploiting.
The government having issued the GO, my lord, on 11/4/2023. Yes, my lord. Yes, my lord. I am already in the process. I will be completing. Your lordship may fix the time frame also. I have no problem.
Let them, my lord. Insofar as we are concerned, my lord, I have taken a stand, we are willing to hand over, provided, let it be, my lord, the earlier violations of, so, all right. Yes.
I'll also file an affidavit. Yes. Very fair, my lord. Very fair, my lord. In the national interest. Because, my lord, around 1,000 and odd crores is already paid.
No,
To the state government stamp duty registration. 600 crores is paid for the.
192 has been paid, my lord. They are supposed to pay us more than 1,000 crores for the earlier violations.
Government of India will pay, my lord.
Yes. Yes. I'll
Very
point
fair.
it out.
Very fair, my lord. Very fair.
And they have
That serves the purpose, my lord. Even if they have real apprehension, perceptual apprehension, maybe it real apprehension, that serves the judicial order of this honorable court. Yes, my lord. I'm willing for that. Because I never wanted to go back. I'm government of India company, my lord. I never wanted to go back. It is money going from one pocket to the other pocket. I'm not a private miner who will operate overnight.
No, they have
to prove my bona fides, my lord, I'm ready. And I will also, my lord, submit to your lordships, my lord, what are the actions taken by us after 11/4/2023. The government after issued the GO. Now the government having issued the GO wants to go back. All right. They may have apprehension now after 23rd April 2023 because of the.
Yes. 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 No, my lord, not designated. Yes. Yes. Short date may be given. Good, April, yes. Before that, my lord, no, my lord, it will take, because they have, I'll take instruction. Everything is in black and white, my lord. What are the conditions I have to fulfill? They are in black and white. No, 3 weeks, my lord. Yes, yes. Very good. The need of the nation and the unfounded apprehensions can be clarified. I'm obliged.
This number 9, Shivkumar KV.
Case, please. Lord, in these matters, my lord, the petitioners have been granted quarrying leases in the year 2017, my lord. When the quarrying activities were in progress, certain villagers of the Muttige village made a complaint to the District Legal Services Authority. District Legal Services Authority, my lord, recommends, writes a letter to the Deputy Commissioner to take action to preserve Gomal lands. Whereas, my lord, the lands in question is, my lord, is a government land.
My lord, similar matters are there, my lord, and my lord has directed us not to precipitate.
My lord, even in spite of that order, my lord, my one humble request, my lord.
My lord,
One
it's
humble request.
posted to 6th of June. My lord, here what they have challenged is the notices, my lord.
Notice is in the nature of an order, my lord. My lords may now kindly see the notices, please, my lord.
Precipitate, sir. It's coming up for the first time.
My lord, they will not, but my lords may now kindly see the notice, my lord. Notice, my lords may now kindly see the notice. It is at page 319, please. They have asked me to stop the quarrying activities, which is being conducted from 2017, please, my lord. My lords may kindly stay the notices, please. The 319, please.
My lord has directed us not to precipitate, and considering it's pending before my lord, we will not precipitate.
But this notice has to be stayed, my lord. Sir, court officer.
Yes, my
Yes.
lord, yes.
Yes, my lord.
Yes,
It is
but
arising
my
out of
lord,
the
they have
same cause
gone
of
a
action
step
310
ahead
to
and issued
2024.
notices.
After passing of the order.
My lord, it's the order is here, my lord.
It is at 305, my lord. It is at page 305. Yes, my lord, it is at 305 page. The last page, my lord,
Legal
it
Services
is at
Authority.
292, please, my lord. Lords may now kindly stay the notice.
Yes, my lord.
Though the, yes, my lord.
My lord, it is based on the report is what they say. Based on the report of the district and sessions judge, this is passed. My lord, on an interaction, my lord, it was observed that there are some violations. Now, since my lord has posted this on the 6th, saying that please do not precipitate, my lord, I undertake not to precipitate.
Lord, with the due respect.
There was no notice issued, but in this case, notice has been issued, which is produced as annexure RSNT, all dated 6/2/2025.
This is with the interim order is with reference to the DLSA authority 3/10/2024, my lord. It is generally applicable to everybody. My lord, after passing of this order, my lord, the notices are issued. Notices are in the nature of an order. They have asked me to stop the quarrying activities, which is being conducted for the past 7 years, my lord. I request, my lord, my humble request is to stay that notice, please, my lord. Notice is in the nature of an order. Please, my lord, 370. Yes, Lords may now kindly stay the notices, please, my lord. Notices are all in the nature of an order, please. Lord, they had issued earlier notice. I have replied that he has not passed any orders on that, stating that DLSA has no authority to go into the issues.
Lord,
No
here,
terms and conditions of the lease deeds are violated. EC conditions are not violated.
Yes, my lord, because
they have
that-
precipitated. They have precipitated, my lord. My lords will now kindly say, I will have to file. That may kindly be stated, please, my lord.
My lord, it's coming up for the first time, my lord, and my lord, this notice doesn't refer to that district legal services report. It only says complaints have been received. And now since it is pending before my lord, I cannot disobey, my lord. District, yes.
Yes,
A reference one made. Here it's not there, my lord will see it, an extra.
The DLSA's authorities order is there, the direction to the.
Yes.
Yes, my lord. Here also it is the same.
No. Please see the notice.
Same order may kindly be passed, please. Lord, the fourth respondent, my lord, is the head of the district task force committee. My lord, district task force committee cannot review its own order, my lord. The district task force committee has recommended for grant of a quarrying lease in my favor as far back as in the year 2014. Now the same district task force committee passes an order, my lord, to take action in pursuance of the letters of the DLSA, my lord. With due respects to DLSA also, please, my lord. The notice itself is in the nature of an order. There is no violation. Notice is not issued under any provision of law is my respectful submission. Notices ought to have been issued under the provisions of Rule 6.3 or whatever it is, my lord. Therefore, my lord, I seek for stay of that notices, please, my lord, which is in the nature of an order. I cannot also reply to it. My hands are tight, my lord. My lord, the 25 families are dependent and I'm required to pay regular EMIs to the bank. My lord, I have established a huge infrastructure. Monthly installments itself is running into several lakhs of rupees, please, my lord. Mining activity, quarrying activity cannot be done in a small amount, my lord. It needs huge infrastructure, huge labor force, employment. 25 families are depending upon this. There are 3 quarrying leases. All the leases are stopped, my lord. my lord, the legal, district legal authority, my lord, has no. Please, my lord. It is at page 300. In this letter, my lords may now kindly see the earlier notice, please, my lord, which was issued as far back as in the year, for which I have replied. No, I have also, my lords may now kindly see page 43, please, my lord. Page 43, the earlier notice.
My lord, immediately information goes to the senior geologist not to, my lord, interfere.
Even then, my lord, this order is passed. My lord. The impugned order is passed.
No, this is coming up for the first time, sir. You
That
were
is
not
true,
the
my lord.
party earlier on.
With due respects to my learned government advocate, my lord, they initially the first, my lord, initially the order was passed in WP number 1318, my lord. Immediately it was communicated to the senior geologist, Department of Mines and Geology. Even in spite of receipt of that not to precipitate order, my lord, these impugned orders are passed. It is generally applicable, my lord, for all the quarrying lease holders. It is at page 45, please. First notice. 45, please. For which I have replied, my lord. I have stated that District Legal Service Authority has no authority to. No, my lord. The District Task Force Committee's recommendation is not there. But the order passed by the Deputy District Task Force Committee is there, my lord. 4/11/2024. My lords may now kindly see the letter addressed to the senior geologist by the Deputy Commissioner, my lord, wherein yes, my lord.
Lord, and he's violated the conditions, my lord, my lord.
No, I have not.
My lord may take internal page 2, page 46. My lord, paragraph 3, the geologist of this office, my lord, gets it. Conducted by a site inspection of the building quarry lease granted to you and submitted a report. As per the said report, it was found that the quarrying was not carried out as per. Yes, my lord. Yes, my lord, 6th of June.
My lord, one sentence, not to cancel the lease, my lord.
We will not.
My lord,
do anything.
not to cancel the. My lord, in pursuance of this, I have stopped my quarrying activities where the senior geologist says not to conduct the quarrying operations. My lord, the next step, my lord, will be he will cancel the lease. Please. A similar order is passed, my lord. Not to precipitate is the order. Please.
Number 10, so surely. The matter pertaining to deemed conversion under section 95(9) of Karnataka Land Revenue Act. Not a petitioner being owner of the land had applied for a quarrying license. 95(9).
My lord, I'll take
similar order.
notice, my lord may have this after 10 days, my lord. Yes, ma'am.
This is number 11, Mr. Mahendra, sir.
This is for unanimous to consider my representation. The application of the petitioner has been processed as per the amendment of Karnataka Minor Mineral Concession Rules. The similar matter, my lord, your lordship was pleased to direct the authorities to consider the representation within 2 weeks.
My lord, I'll take notice, my lord.
This is also 8B. The consideration is under Lord 2023 Amendment Act.
Yes, no, my lord, I'll take note.
A short date may be fixed, my lord. 2:30, my lord. Okay. Obliged.
Obliged, my lord.
This writ appeal matters, seal number 12, Mr. Ravindra Reddy.
I appeal for the petitioner, my lord, in this case. My lord, this is the appeal against the order of the learned single, my lord, wherein the petition was dismissed only on the.
There is a delay, Mr. Counsel. Delay of 28 days.
Yes.
So notice in that delay application. Yes, next.
Seal number 13, Mr. Abhinay V.
Same.
For the appellant. In this case, a batch of writ petitions wherein pro rata charges has been challenged before this
Then
honorable.
again, when it is kept.
15th of April, it is listed.
Notice written on 15th April, both in appeal as well as.
May I
in-
be permitted to take
No,
notice
no,
against the standing counsel, Your Honor?
Give copy. 14.
Number 14. Mr. Bhuvanendra Raju.
Here for the appellant's counsel. That's the appeal of the petitioners is dismissed. Oh, yes. The learned single judge, my lords, holding that there is a cloud on the title of the appellant. Though there is no cloud, my lords, so far as my vendors are concerned, there is no. The only issue is, my lords, this. There are two branches. The land granted to petitioner's branch where we trace our title. My lords, this 21 guntas was granted in 1958, my lords. The title which is traced by the fifth respondent, my lords, they, the title, my lords, grant is for 16 guntas. From 16 guntas, it has become 21 and 1 acre, 2 guntas. Revenue authorities have to decide on that. Title documents are there. Instead of that, my lords, they say there is a cloud on my title. That's not even a question before the revenue authorities. Original grant certificates, my lord, show what is granted to us, what is granted to the other side.
So you are also a registered sale deed purchase.
There is a registered, my lords, it's.
Friends also purchase by registered sale. deed.
Yes, but my lords, I trace my title through one Muniappa, my lords, who was granted land in 1958, admitted fact.
Civil litigation is.
My lords, so far as we are concerned, there is no civil litigation. The fifth respondent files injunction suits against others. So I can't be held liable for that. Lords, it's only like this.
Today mutation stands in whose name?
It has been made over in their name, fifth respondent's name, for 1 acre, 2 guntas. When their worth, my lords, if I can, I'll have to trace my title to some grant. Their grant title shows only 16 guntas granted to their vendor's vendor. How it becomes 21 guntas and how it becomes 1 acre, 2 guntas is not even seen by the revenue authorities. We have produced the grant certificate before all the authorities, which shows.
Single judge read, ultimately the civil court decision will rule.
So I'll have to go to a civil court, I understand. But the revenue entries can't change like that. Lords, any entry should be based on title. I am only saying this.
So both are claiming through registered sale deed. Both
Both,
sides.
yes, but my lords, I am only saying this. My original grantee from whom I trace my title.
That will be decided by only civil court.
No, my lords, but the revenue authorities, while changing the entries, could not have changed it to 1 acre 2 guntas in favor of fifth respondent when their grantee was given only 16 guntas. If he was originally allotted 16 guntas, how it becomes 1 acre 2 guntas? It's the revenue authorities should have at least seen that aspect.
So 1 acre and
2 guntas it is made over to their name
the grant is,
for 16 guntas, 1/6.
that is admitted position.
Lords, that is the original record. There is no answer by anyone. I have produced the grant certificate, which is at Annexure D, page 79. So far as I am concerned, 21 guntas, I am not seeking not an inch more than 21 guntas. Their grant is at Annexure G, page 97 for 16 guntas. 3 sales have taken place from 16 guntas, it becomes 21 guntas. From 21 guntas, 1 acre, 2 guntas. This aspect of the matter, revenue authority has to give an explanation how it becomes 1 acre, 2 guntas from 16 guntas. And my vendors, there is no dispute with my vendors.
In the suit, you are party.
No, I'm not a party in those suits which the learned single judge refers. No, I'm not even a party in any of those suits. Those are injunction suits being filed. The authority holds since the GPA holder, one of the GPA holders was dead by the time registered sale deed was executed. That can't be held against me.
So original suit number 86 of 23 relates to same land.
Pardon me.
Suit number 86 of 23 is subject matter of the very land.
Yes.
Must be 1 acre and 12 guntas total.
86 of 23.
Now, Lords, my instructions are, we are not parties. He keeps fight.
No. You are defendant in also. Yes.
Lords,
Again,
the question is on the entry, my lords.
492.
488. 488.
Subme.
488.
Sorry, Mr. Fernandez.
Lords, that is by Manjunatha. Please see the plaintiff therein, my lords.
Why should we interject when the suit is pending? 7 suits, 6 suits.
Lords, those are all by different persons, not by the respondent. Please see
But the
488.
subject matter land is under dispute before the civil.
Lords, that is by Manjunatha, not even by the fifth respondent.
We'll say the mutation entry will be guided by the outcome of the suit.
That's right, my lords. That is always, that's the accepted position. But my lords, if the revenue entries, without any basis, if they keep making it into 1 acre, 2 guntas.
Or at the best, we can clarify that there shall be an endorsement below the entry that these suits are pending.
They're saying the endorsement in the RTC, suits are pending. Lords, at least that, because tomorrow it should not happen. What happens? My lords, our concern is, based on the revenue entries, sales take place. If at least there is an endorsement or endorsement in that they are.
You are claiming how much? 1 acre and
21 guntas I am claiming.
21.
The fifth respondent is claiming 1 acre, 2 guntas.
That entry today, mutation entry will be subject to the rider and endorsement, that it will remain subject to outcome of the suits in which the petitioner claims 21 guntas.
Very well.
That's all. That must clarify.
Very
Dispose of.
Very well.
No interference except this clarification.
Please.
We'll pass you.
Very well.
Let's also sixth and seventh respondent in the writ appeal, may I delete them because they are dead, my lords. I wanted to bring it to my lord's notice.
To private.
I'll file a memo to delete sixth and seventh respondent, who are my original vendors and vendors' brother. They are dead, my lord. So we want to, that has not been, unfortunately, not been brought to the notice.
Five respond.
Five is mine.
Total land is 1 acre and 3 guntas, 12 guntas, 2 guntas.
According to us, 1 acre, 2 guntas.
Out of which 21 guntas you are.
We are claiming.
You're filing memo?
We'll file, Madi,
Very well.
to delete 6 and 7. my
We'll
lord.
alert the memo, expose the memo and pass the order.
Please.
Clarifying the mutation stand with clarification. Yes.
Yes. 15, 16 are urgent. Seal number 17 is a commercial appeal. Saravana, yes.
Not withdrawing this petition, madam. Permitted to withdraw this petition, madam. I'm withdrawing this petition, madam.
Withdrawing, learn and educate Mr. So-and-so who seeks permission to withdraw the commercial petition. This present commercial petition. Commercial appeal. Dismissed. The memo dated 24/3/25 is rendered on record for the purpose of withdrawal, seeking withdrawal, praying for withdrawal, full stop. The commercial appeal is dismissed as withdrawn.
Please, madam. Much obliged.
Seal number 18, Rukojira.
May it please, my lord, appear for the respondent.
Who is for the appellate?
Rukojira.
What to come? Take a matter.
Next.
May I request, my lord, that the seek it,
We are not seeking for time.
if there's some inconvenience this afternoon, my lord.
Naturally, it will come afternoon only.
He came.
In this-
Appear for the appellant in this matter.
Yes.
This appeal is filed against rejection of my section 9 petition, my lords. The lordships will see the impugned order, my lords. It starts at page number 23. The operative portion is at page 29. The reasoning, paragraph 9. May I read, my lords?
Yes.
Page 29, para 9.
So it was section 9 application.
Yes, my lords. It was a section 9 for interim measure. Initially, an ex parte order was granted, my lords. Thereafter, the petition was dismissed, my lords. Primarily on the ground, my lords, that we have not initiated arbitration within 90 days, my lords, as required under section 9, subclause 2 of the Arbitration and Conciliation Act. The lords will see para 9 on page 29, my lords. The learned counsel for the respondent submitted that the applicants have obtained interim order from this court in the month of Jan 2024, and they have not yet initiated arbitral proceedings, and therefore the present application may be rejected and interim order may be vacated. Thereafter, two judgments are cited. Then your lordships may come to para 10, my lords. This court has already passed an order restraining the respondent from doing unauthorized communications with ICA Motors or any other vendor. Absolutely, there is no whisper about the violation of this order by the respondent. Whether the respondent is having custody and domain over the server of LLP or not is not made out, and therefore there is no need to direct the respondent to share login information and password to the other two partners. Similar observation can be made with respect to prayer 3 and 5. It is not made out that the respondent is still having custody of books, accounts, GST returns, and therefore granting of prayer 3 and 5 does not arise. Without there being any adjudication, it is not possible to hold that the respondent is liable to pay rupees 1 crore to the LLP. The applicant having not shown much interest in getting the matter settled through arbitration, the present case is pending since 1 year. Absolutely, there is no allegation against the respondent that despite the present petition is filed is causing damage to the LLP. Therefore, this court do not find that this is a fit case to invoke Section 9 of the Arbitration and Conciliation Act to grant interim measures as sought for. Both factually and legally, this is incorrect, my lords. The finding of the commercial court. Factually, it's incorrect, my lords, because they had appeared and they filed 2 memos, my lords, seeking the matter to be referred to arbitration, to mediation. Because of which, my lords, the matter was pending before the commercial court for a long time. Because of which we were bona fidely participating in the mediation proceeding, and we did not initiate or file a CMP before the Honorable High Court of Karnataka under Section 11, my lords. Factually, legally, it is incorrect, my lords, because under Section 9, it refers to commencement of arbitral proceedings. Here, my lords, before filing of my petition, my lords, I have issued notice, my lords, and it amounts to a commencement under Section 21 of the Arbitration and Conciliation Act. We have commenced the arbitration proceedings, my lords. Section 21 defines commencement. Even before filing the petition, I have issued a notice invoking the arbitration clause, my lords, and we have commenced in terms of Section 21. That is not considered by the learned commercial court, my lords.
But then your prayers in Section 9 application are all those which can be granted.
My lords, I'm only pressing the first relief now, my lords. I'm not seeking any other prayers. Only first one, let them not indulge in any unauthorized communication with the vendors or of the LLP. That's all I'm seeking. I'm not pressing any other reliefs, my lords.
It is too omnibus of it.
My lords, because under clause 27 of the LLP agreement, there is an obligation on them, my lords, that they should not disclose the confidentiality.
Let us see.
Yes,
may
I'll
I-
just show
my lords kindly. The appellants are guilty of suppression of material document before this honorable.
No, we are asking.
I'm on the relevant point, very relevant point.
Yes, we are asking these all prayers.
Yes, ma'am.
You're not pressing any other prayer.
Only the first one, my lords.
First one, you are pressing on what basis?
My lords, clause 27 of the.
Where is that?
Yes,
Page?
if I may just pass on the trial court records. Ma'am.
Page number. Page number.
Page. Page number 39, ma'am.
It is.
The clause begins at page 38, my lords, clause 27, confidentiality. This is the amended LLP agreement governing the dispute. Page 28, my lords, at the bottom, confidentiality.
Where is that instance that they are divulging with confidentiality?
My lords, they in email, my lords, in writing, they have threatened, my lords, that they'll divulge confidential information. I've produced that WhatsApp communication as well as email, my lords.
Where is that?
Page number 157, my lords. There's a WhatsApp screenshot which I produced at page 157. Second para, my lord, the minute I make a move, Royal Enfield will restart the dealership financial due diligence. If or not, you may get back the dealership is up to them. You want to take this chance, then let's do it. Then there is also an email communication on page number 144.
This is not.
May I submit?
Page number 144 also may be seen for a moment, my lord. The email at the bottom, my lords, dated 10 Jan 2024. Please go ahead and let me know. I'm forwarding necessary and relevant mails and information to ICAR as I should and can, and you are welcome to contest how you want. But it is my moral and legal obligation to let the brand know that there is such transpiring situations. I'm surprised how you are threatening me to hide this from the brand, as you must have already informed by now. And since you are trying to hide it from the brand, I have to step in and do your job as usual. Therefore, my lords, he is threatening in writing to disclose confidential information to ICA Motors, which is the dealership here, my lords. That is one thing. And that WhatsApp communication which I showed, my lords, even there, he is threatening to divulge confidential information pertaining to the LLP. That is all I am seeking, my lords. That clause 27, as per clause 27 of the LLP agreement, let him not divulge any confidential information, my lords. If that information falls in the exception to clause 27, then that the arbitrator will decide. I'm just seeking an injunction in terms of clause 27, my lords.
May I please, my lord? Kindly refer to page 144, which my learned friend, the language that is deployed is that please go ahead and let me know. I'm forwarding necessary relevant mails and information to as I should and what's. And you are welcome to contest you want, but it's my moral and legal obligation. By this legal obligation, my learned friend, the appellant, has not only suppressed the contract that was entered by the firm with Eicher Motors before the lower court, but also suppressed this before my lords. There is, kindly see my statement of objections. I have produced the document. It's a contract that was entered between the firm and Eicher Motors. Kindly come to page 40 of my statement of objections. Page 40, point number 4.2.
Page 40.
Page 40 of my statement of objections, 40. My lords will find dealership agreement. One second. Page 38 onwards. Dealership agreement at page 38 is between Eicher Motors and Maverick Motors LLP. This is a partnership firm. And there is a legal obligation, statutory, that is contractual obligation at page 40, para 4.2. The dealer of my statement of objections, my lord.
The statement of objection.
Yes, ma'am. Statement of objections, page number 40.
Dated.
Up to the appeal memo, my lord, it is dated 19th March 25.
Hmm.
38 is the agreement starts on 18th August 2022
Hmm.
between Aisha Motors and we are franchisee. Maverick Motors is a franchisee for Maverick Motors. And relevant point will be point 4.2 at page 40. The dealer agrees to notify the company, that is Aisha Motor, of any changes, variation to its shareholding, voting, or management during the tenure of its agreement. It shall also notify company any material legal proceedings initiated against it or by it, provided that all legal proceedings are initiated by the customer and those affecting retail stores, etc. There is a legal obligation. The firm has entered into a contract as a retailer for Enfield Motors, that is Royal Enfield motorcycles. When the dispute arises between the shareholder, between the partners, and it is our duty as obligated under 4.2 to immediately inform the dealer as such. That is the reason it was mentioned very clearly. And moreover, what happens if I don't communicate and it escalates into a litigation, which is already into a litigation, the arbitration proceedings has started. Aisha Motors may suffer any loss or the entire firm will be sued for damages. Pursuant to the interim order, we kept quiet, hoping that there'll be a resolution. And kindly see, even the contract which my learned friend pointed out, where is the partnership agreement? Clause, kindly see clause 17 in the same statement of objections.
So
This 27, my lord, page 26.
Respondent here is also partner.
He was a partner, my lords. He has only 0.01%.
They cannot even, it's a limited liability partnership.
0.01%. We have invested 3 crores. They have invested only 40
That
crores.
is not the issue. One is, my lord, one is,
Let us understand at least factual.
Yes.
Respondent is a partner.
Continues, according to me, we continue to be a partner. They sent a notice that they have expelled me.
So LLP was between Aisha Motor and Maverick Motor.
No. LLP is between the appellants and the respondent.
Appellant respondent.
Appellants and the respondent. They are the 3 partners.
So and
Irrespective of whether I am 1% partners or 10%.
dealership agreement between
The LLP entered into a dealership agreement with Maverick, Aisha Motor. So if there is a breach of the terms between Aisha Motors, there is already a dispute, there's already a litigation. And one hand, they say they have expelled me from the partnership firm.
litigation
Between the partners as such. This is arbitration proceedings and they expel me as a partner. And that's what I pointed out. There's an obligation cast upon the firm and the partners as such to intimate if there is a change in management or any dispute or any litigation as such, which we wanted to. We have not done. Kindly appreciate, my lord. We just said that please either resolve it or we may have to escalate it and take it. So they rush and initiate, send a notice, and very same day, very next day, they file an arbitration proceeding and get an ex parte order. We remained quiet, honoring the order until then, and mediation was proposed. And I'll kindly see the list of dates that I provided, which my lords will see at page 2 of my statement of objections. Here is the case where they suppress the main document. They want an order, gag order against me, not to disclose anything, but suppressing the main document. Is it not a fraud on the court? That fraud continues even before this honorable court. In Chengalvaraya's case, material document suppression is nothing but a fraud. Page 2, my lord, of my statement of objections. This is a list of dates. 24/6/2022, LLP was constituted. 18/8/2022, dealership agreement was entered between Maverick Motors and Asia Motors. 15/10/22, there's an amendment made to that. And 18/1/2024, they issue a notice invoking arbitration proceedings under section 14. 19/1/24, they initiate, the very next day, they filed this commercial suit. Interim order was passed on 20th. We enter appearance on, after 1 month, we gave the notice, we enter appearance. On 5/6/2024, we filed, we sent a reply notice. On 15/6/2024, the matters refer for mediation. Kindly see, my lord. From the time they sent the legal notice, that is on 18/1/2024, till 15/6/2024, almost 6 months, they enjoy an interim order. They don't move this Honorable High Court under section 11 for appointment of an arbitrator. Arbitrator tribunal is not constituted. It's only after 6 months the matter goes for mediation. There should be some honesty when they're making. And they filed the civil miscellaneous petition, which we learn only through the plea. Only this year, up more than a year. There's no fault in the order of the commercial court in vacating because it followed the dictum of this honorable court. Which is it? Court office. A division bench of this honorable court. When was order vacated?
No, arbitration has started.
We have filed a CMP, my lords, which is pending. We had informed them, my lords, when it got listed, but they didn't appear, so notice was issued to them.
There is no appointment for arbitration.
No, it has not yet been
My
appointed.
lord, kindly see that when they filed the CMP proceedings, 1 year, they enjoy an order, ex parte order. 1 year
can
they
show my
tackle.
conduct from
Sorry,
the order
that's
sheet.
the conduct. Please don't talk about the conduct.
Sir, let me make my
No,
submission,
I'm
sir.
on my
making
leg and you are
submission.
intervening.
I'm entitled to make my submission.
You make
I
a
show my
submission, my
conduct from
friend.
the order sheet, my lords. I have the order sheet of the commercial. Your lordships may see
That's
every
why
day,
my
they
learned
don't
friend
take
extend the
objection for 1
courtesy.
year.
I was submitting to the court and you're intervening. This courtesy is not extended. It's unfair. You may continue then.
Since your lordships asked that question, I'm answering that, my lord.
That's not fair.
Well, yes, my lord.
And yes,
My lord, as I said, when did they file the CMP is a question. One is, the law says within 90 days after filing a section 9 petition, they should initiate get the arbitrator appointed. The contract, as I pointed out, my learned friend said, oh, we got misled by mediation. For 6 months, They don't even file an application for CM, appointment of an arbitrator. They filed a CMP petition this year, after 1 year. And first and foremost, as I pointed out, kindly see the judgment of the Honorable Division Bench of this Honorable Court, which the trial court has referred to. This is in MFA 668 of 2019. The learned judge has referred to this case. Kindly come to para 12, para 15 of page 12.
Today it is dissolved.
My lords?
No, is the LLP dissolved? No, sir. It's not dissolved. Let's say it dissolved.
No, my lords, it's
They
functioning.
sent simply a
They have been
notice.
expelled. The respondent has been expelled from the partnership, my lords, for committing a fraud of more than 1 crore. There was an independent auditor who was appointed. We issued a show cause notice. As per the LLP agreement, 30 days show cause notice is required. In spite of service of show cause notice, it does not appear. It does not account for how this 1 crore has been diverted. Nothing is done. Therefore, my lords, as per the LLP agreement, he has been expelled from the LLP partnership, my lords.
My lords, look at the conduct. An
And the-
allegation of 1 crore is being made against me.
There's an independent
I'm
auditor.
talking like a friend. This is not fair.
Every time I submit,
Yeah,
you keep
whenever I
interrupting,
submit, you
sir.
intervene.
Please.
This is the way you have been brought up. Sorry. I'm sorry. And my apologies. Such a conduct is not tolerated. I'm making
The
my
question was
submission. Don't
posed,
you
I am
understand?
answering.
Sorry, you are
The
not.
question was posed, I am answering, that's all.
Making my submission, you're intervening. It's unbecoming of it. It's our decision.
What was granted by the trial court initially?
Restraining them from making unauthorized communication. Yes, my lord. Same
This
thing
was
was.
granted.
Yes, that was there in force for 1 year, my lord. From making unauthorized communication on behalf of the LP is no longer a partner. And it's a limited liability partnership. His investment is only 40,000. His liability is restricted only to 40,000. We have invested 3 crores, my lords. We have 99% ownership in the LLP. And my learned senior pointed out that we had an obligation to inform Iker Motors. We have informed.
So which are the unauthorized communication? Whatever communication is sent by the other side will be unauthorized.
My lords, that's what, my lords. They're threatening to make those unauthorized communications. That's why we are seeking an injunction. Let them not make it. Let them act in terms of clause 27. That's all.
Let us say 27 again.
My lords. 27, my lords, for a moment. Your lordships may come to page number. With that memo which I had given, my lords.
It's a confidentiality. Like there are
Page number 39, my lords. 38 of
38.
that memo of additional documents which I had given, my lords. Page 38. That LLP agreement is there. Clause 27.
Page 38.
Page 38. Clause 27 at the bottom, my lords.
Correct.
A. Each partner shall keep. May I read, my lord? Each partner shall keep confidential and shall not divulge to any third party except in the course of his duties as a partner any information relating to the business or the LLP, clients of the LLP.
Question
My
is
lords,
asked now.
my lords, I'm not being led to make my submission at all, my lord.
I've seen that.
The court asked me now.
I'll leave it to my lord. I'll leave it to my lord.
27A.
Now arbitration was initiated.
Yes, my lords. I filed a CMP, my lords. Notice is issued to the other side, my lords.
We have not received any notice. We have not yet to receive notice.
We emailed it to their advocate as well as the party. Postal also it is being sent. I've also sent by email.
Place on record the notice.
My lord.
I'll place it on record, my lords.
May I submit?
I'll place it on record.
Kindly see the judgment of this honorable court, division bench judge, which I placed.
One, may I
This
just
is
clarify?
MFA 668 of 2019, following another bench, division bench court. As per para 15, page 12, para 15 of the judgment. As per sub-rule 4 of rule 9 of the rules 2001, in case of an application for interim measure made before initiating arbitral proceedings, if the arbitral proceedings are not initiated within 3 months from the date of presentation of the application under section 9, an interim order granted shall stand vacated without any specific order being passed by the court to that effect. These provisions are considered by the coordinate bench of this court in Patent Construction Private Limited, Infloven Projects Limited, and another reported in so-and-so, and it is held as per section 2 of section 9 of the Act, where a court passes an order for an interim measure under section 9(1) of the Act before commencement of arbitral proceedings. The arbitral proceedings shall be commenced within a period stated in subsection. Commencement of the arbitral proceeding within period stated in subsection 9(2) of the Act is made mandatory by Parliament to see that an order for an interim measure passed under section 9 shall not continue to be enforced indefinitely in the absence of an arbitral proceedings. Here, ex parte orders obtained in January 2024.
Now it is started.
Now it's
Yes,
not
ma'am.
started. They make an application for appointment of arbitrator 1 year this year in January 2025. What were they doing for 1 year is the question.
What is the point of time of commencement of the proceeding?
My lord, there are two.
Issuance of notice. Section 21, invocation of the arbitration clause and issuance.
Is one. Sub-rule 4 of 9 rules of the Karnataka arbitration. It's very clear. It says, court rules. It says very clearly that initiation is different from commencement. Initiation means get an appointment of an arbitrator. Yeah, what have they done, man? When did they file the CMP proceedings? It's not when the notice is ordered. Let them place a fact that when did they care to file the CMP proceedings? The CMP proceedings, according to us, has been filed in only January 2025, after enjoying an interim order for almost 1 year. Kindly see the calculation at page 8 and 9 of my statement of objection.
Eighteen 124 notice.
Yes, my lord. And they have replied also, my lords. I have produced that reply also on 5th June 2024 is the reply. 1 day before filing my section 9 petition, I have invoked the arbitration clause.
Invoking the arbitration clause is not in question. The question that arises before this honorable court, which the appellant has to convince us in proceedings before courts.
So you are saying that invocation and initiation are different?
Initiation are different.
My lord, there is a judgment to the contrary. There is a division bench judgment to the contrary.
And it says proceedings for interim measures made before the initiating arbitral proceedings. If the arbitral proceedings are not initiated within 3 months from the date of presentation application, that is 9,
Page
any
9.
interim order shall stand vacated. This is followed by a division bench ruling. In what way can we find a fault?
The second judgment, my lords, page 10, my lords, it begins at page 10.
The
Division
judgment of this honorable court is subsequent to the judgment relied by my learned friend.
Page 19, my lords. Page 19, para 13, my lords.
You copy to this.
I have given, my lords, just now.
Yes.
Para 13. The arguments advanced by the appellant as regards Rule 9, subclause 4 of the High Court of Karnataka arbitration proceedings before the court's Rule 2011 is not applicable to the facts of the present case in view of the proceedings under Section 21 of the Act having been commenced as rightly pointed out by the learned counsel for the respondent.
This is Karnataka or High Court, yes.
Yes, my lords. Division bench, my lords. Page 19, para 13, my lords. It is. Same ground was raised, my lords, and it has been answered stating that.
And what is this judgment relied on by them?
My lords, that does not say, that does not define the initiation of proceedings. This judgment defines. That judgment only is for the proposition that within 90 days, if you don't initiate arbitration, then the interim order stands vacated. But what is initiation of arbitration is defined in this judgment, my lords, at paragraph 13,
So
relying on Sundaram Finance of the Supreme Court.
according to 21 notice.
Yes, my lords.
Is the initiation.
Yes, yes.
That is normally understood.
Yes, my lords. That is the ambiguity which is being created here. That is the settled position of law. Relying on Sundaram Finance, this division bench judgment was passed. Sundaram Finance is thereafter reproduced, my lords, at page number, para 14, page number 20. The Supreme Court has also held the same thing.
In the Sundaram Finance.
Yes, my lords, in Sundaram Finance. That for purposes of section 9, notice under 21 is the commencement of proceedings.
Very.
Kindly see the last paragraph, last few lines at page 11 of the very same judgment, which was extracted from Sundaram Finance. While passing such an order, in order that the effective steps are taken to commence the arbitral proceedings, the court, while exercising jurisdiction under Section 9, can pass conditional order to put an applicant to such term as may deem fit with a view to see the effective steps are taken by the applicant for commencement of arbitral proceeding. What is apparent, however, is that court is not debarred from dealing with an application under section merely because no notice has been issued under Section 21. The fact of the matter is, I filed an application under Section 9, obtain an ex parte order, remain silent. I don't take any initiation, effective steps to appoint and get an appointment. We have not agreed on an arbitrator. The only recourse under Section 11. Section 11 application should have been filed before this honorable court seeking an appointment. Has this been done? Is it someone wants to gloss over an interim order without taking any steps? I remain patient. And matter was referred for mediation, hoping that mediation will fail. But it failed. When was the matter referred for mediation? January ex parte order. In month of June, matter referred for mediation for 6 months. Or beyond a period of 90 days, they keep quiet. And there was referring for mediation did not hold their hand from filing a CMP proceedings before this honorable court. From mediation failed in September. Nothing prevented them from filing. The issue is, my lord, is simple. Whether there is a legal obligation for me to disclose to, I am a partner. Is there a legal obligation for me to disclose that there are differences between the partnership? If I put myself in the shoes of Aisha Motors and look at that perspective, when my dealers, the partners in a dealership are fighting, will my business not get affected? Who's going to service and the sales that are being affected? If this partnership is shut by any litigation whatsoever, what happens? These are the questions which has to be answered. The contract, which on confidentiality, talks about what are the exceptions. I may not, in the course of my business as a partner. 27. Para 27, which my learned friends relied upon, the LLP agreement. Each partner shall keep confidential and shall not divulge to any third party except in the
Yes.
Except in the course of his duties as a partner. I have a duty. As a partner, I went, the partnership I signed into an agreement with Aisha Motors. And so in the course as a duties as a partner, I'm not out of it, but as a partner, I'm obligated to protect the interests of the firm. When it protects the interests of the firm and from preventing a larger liability, I'm also protecting the interest of the other partners too, which is totally lost in the course of this proceeding. Any information related to business or LLP, clients of LLP of the terms of this agreement, in any other information, confidential nature is received in relation to LLP or other partners, save in respect of confidential information, these are the exclusions. Is disclosed with written consent, is already in the public domain, otherwise done as a result of breach of this para, is disclosed pursuant to a legal and regulatory obligation, in which case where permitted by law or regulation, advance notice of such disclosure shall be made to the LLP. There's a contract. There's an obligation for me to inform that once there is a dispute or anything that affects the interest of the partnership, I will not, my lord, to kindly appreciate my conduct. I put them on notice. I sent an email. I will be doing it because as per, I'm legally bound to do so. There's an obligation. It's disclosed pursuant to legal or regulatory obligation. There's a legal obligation as per contract I need to disclose as a partner. They may like to suppress. But if there is a dispute among the partners, there's a legal obligation. And why have they not filed the agreement between Aisha Motors and me before the trial court, not before this honorable court? That amounts to fraud is my humble submission. Question is, Now that if they initiated the arbitral proceedings, I'll certainly appear, whatever the date, I'm not shying away from notice. I'll appear, let the honorable court appoint an arbitrator in its wisdom. And let the matter can be contested, making allegation whether I was swindled one, who swindled whom should be, is a question.
May I just reply, my lord?
The division bench of the honorable court says that they can't take undue advantage after getting an ex parte order, dragging your feet without filing, initiating taking steps, in this case, to appoint an arbitrator, filing CMP. 1 year they keep quiet.
May I just make my reply?
Pilkan, anything you want to say?
Yes, my lords, regarding my conduct, my lords, I'm producing the order sheet of the commercial court. Not a single adjournment I've taken. It is at their request, the matter was referred to mediation twice. They file a memo before the commercial court twice seeking reference to mediation. And it is at their request the matter gets referred. And every time they don't file objection, they file objection after 1 year. On the very next date of them filing the objections, I've argued my matter, my lords. And secondly, on law, let me come. Secondly, on law, my lords, invocation has happened even before I filed section 9, my lords. And they have replied after 6 months to my invocation notice after section 9 was filed. And thirdly, my lords, with respect to the obligation to inform Iker Motors, my lords, we have informed Iker Motors. Managing partner, I am the managing partner. I have appellant number 2. And we have informed Iker Motors. It's not that we have not informed Iker Motors about reconstitution.
So we are reserving it. If you want, either of you want or both of you want to give some synopsis,
We
give a day after.
Much obliged.
Reserved.
They had given an undertaking, my lords. Let that continue till your lordship.
My lord, the only thing is they just
Recorded.
passed on information.
Yes, my lords.
They have
Last date.
already informed. They have already
Or learned
informed
advocate, Mr.
Aisha
Solis.
Motors of a dispute. That's it. We have nothing else to do with, I think.
My lords.
They themselves say that they have disclosed to Aisha
They already-
Motors the dispute.
If it is by order, they will continue.
I gave.
My lords, it's noted in the last order.
Now that my lords have reserved, my lord, kindly see, doesn't serve any purpose. Because meaningless.
Once it is reserved, what is there, it is continued.
Uh,
Whatever.
That's all.
Whatever.
That's all I'm seeking, my lords.
The dispute, they themselves have informed Aisha Motors. There's nothing for me to inform them.
I'm only asking unauthorized communication which violates confidentiality, not just to
Or
Iker
learned
Motors, to other vendors
advocate,
as well.
Also assisted by learned
Not just Iker Motors.
for the appellant and learned senior advocate, Mr. Swanson, assisted by learned respondent at length. Full stop. Learned counsels for the parties stated that they argued the appeal finally. They further stated that the readings are complete and no further are required to be added or supplemented. Reserved for judgment. Full stop. Since the judgment is reserved, comma, the observations and directions contained in paragraph 5 in order dated 5/3/25 shall continue to operate subject to the outcome of the
Much obliged.
As a matter of fact, my lord, my learned friend says, I've not replied to the notice. The practice is when an initiation of a notice for appointment of arbitrator happens, it is always advised, agitate before the arbitrator, don't disclose your cards before in a reply notice or in a CMP proceedings. Because CMP is as it is and more on the administrative side. Why burden the court with all the litigation? Whether there's an arbitrable dispute or not. That's where it is. Whether I'm accepting in the notice for an arbitration or not. Once they bypass and send the notice before the ink would dry, immediately they rush in. Maybe next day they file a petition and get an order. So where is the question of whether I may not even reply. I reserve all my defense before an arbitrator. I may make a counter claim. May I just request, sir? May I just request a slight addition? Since my learned friend has first then shared an email to us saying that they've informed Asia Motors, let it come on mention that they've already informed. Because from my side, we are not going to do anything with Asia Motors.
No, no, we have reserved it. Nothing.
I'm not
All-
filed
all
it in
in-
that court.
All in judgment. Now, if you want to give written synopsis, give
Yes.
by day after tomorrow.
I'll file.
Beyond that, we will not accept.
Much obliged.
Seal number 19, sir, writ petition PA, Mr. Raghavendra G. Gayatri. Seal number 19.
My lords, this is regarding that construction of road. My lords, on the last date of occasion had directed, my lords, whether to get instruction regarding whether road work is completed or not by the council for the municipality. Is not there.
Which road?
Lords, regarding construction of road, my lords, which is not completed, as per my lords, annexure C and D. Lords, plan was sanctioned for construction of road. Lords, may kindly come to page 93. From Burdu Junction, my lords, to Kallapu Junction, including connecting roads. It was not constructed. On that ground, my lords, PIL was filed. On the last date of occasion. My lords had instructed the council to get the instruction, what is the status of the road. He is not present.
TMC should reply,
This
madam.
is of 21. It must have been constructed.
Not yet, my lords. My instruction, they are not constructed it.
What is that length, sir, the
My lords,
length of the road not constructed?
my lords, from Kallapu Junction to Burdu and Gandhi Cross Road.
Where do we get it?
My lords,
Where
my
do
lords,
we-
page 129
Page 129.
is the entire cost estimate. Serial number 14, development of road from Kallapu Junction to Burdu, Gandhi and Gandhi Cross Road. Tabulation of cost estimation is there.
So Kallapu Junction to
Burdu,
Urdu.
Gandhi and Gandhi. Roads from Kallapu Junction to Burdu is completed. Then they leave it off. From Gandhi and cross roads are not completed. To that extent, my lords, last date, my lords said directed to get the
What
instruction.
is not completed?
From Kallapu Junction to Burdu is completed. From Gandhi and cross roads are not completed.
Gandhi to Crossroads.
Yes, my lords.
So this is pursuant to some
Government order dated 6/6/2017.
development of road from Kallapu. Pursuant to some, what?
Lords, Nagarothana scheme, my lords.
Scheme.
Scheme.
They will complete within 3 months.
They have. But no, then I'll take instructions and I'll make.
Take instruction, there is nothing. We are not here to.
My lords, construction of
So
road is-
you take instruction. Send out to
Not any date with my lord.
any date in the month of April, May.
naturally, 4th April,
My lord, 4th is too short, my lord, maybe 9th.
7th April. Send out to 7th April to be listed at 2:30. On which date learned additional government advocate Srimati Neelofar Akbar shall take instructions regarding the grievance about non-completion of the part of the road in Pest.
So also, my lords, respond now. Advocate for respond number 5.
Who?
Lords,
He appears for
Advocate
city
AK Bhatt.
municipal council, my lord.
Who appears?
Lords,
A.
AK
Keshav
Bhatt,
Bhatt.
sir. A. Keshav Bhatt, sir, appears, my lords. Today he is not there. Last date, my lords, sir, directed him to take the instruction. Today he is not there. It may.
Then wait then. Wait, keep it.
Pass over.
Oblige. I'll
Number 20 is adjourned. Number 21, Mr. Jagan Mohan MT.
Petitioner, raise some time to make submission. Raise some time to make some data submission. Yeah.
Yes, what is it about?
And I press some time to make my submission in it because I have to get some more information from the petitioner. It's not, really have it.
Go after it. Replies, sir.
Not at Mellon. Will Mellon is at Mellon. I represent Bangalore University. We have nothing to.
Here, there is a fee regulatory committee or not?
Pre-regulatory committee is there, my lord. Yes.
So go there.
Given some representation, but they're not considered annexure A and B. Isn't it? Annexure A at page number 74. Annexure A. Annexure B. At 84.
You are for?
Lord, I undertake to file power for the ninth respondent. It's a Association of Management of Nursing Institute.
I represent fifth respondent, Mellon, University.
You are for whom?
Lord, ninth respondent, I made. Lord, in fact, a similar petition, my lord, with a similar prayer is filed by him in 2019, my lord, WP 43236, which is still pending, my lord. In that matter, my lord, since it did not appear, my lord, time was granted. Now it is posted to 15/4/2025 as a short time to engage a lawyer, my lord. There, the petitioner here appears party in person. Page 13 may kindly be seen, my lord. He says about it, but the number given is erroneous. Page 13 of the petition, he says that similar PIL is pending, but the number mentioned therein is not correct, my lord. The correct number is 43236 of 19. 43236 of 2019. Similar prayers are made. It's filed in 19. Once again, in 23, he files this petition.
In the other petition, any order is passed?
No orders are passed, but he'll be taking time, my lord, and ultimately when the court expressed that they would dismiss the petition if he doesn't make an arrangement for a lawyer to appear for him, my lord, he sought time. My lord. At the last occasion also he has sought time. Matter is slated to 15/4/2025. It was listed on 19th of March, my lord, before this on.
What is the agreement?
My lord, during the academic year 23-24, my lord, the government proposed to conduct entrance exam to BSc nursing courses, my lord. At that point of time, my lord, the institutions approached the honorable minister, my lord, at his intervention, my lord, a consensual agreement.
Consensuous agreement between Karnataka and.
A consensual agreement was entered, my lord. My lord, that has stood itself expired, my lord. That was for the academic year 23-24. There was an entrance exam proposed for BSc nursing courses. There, my lord, in fact, the government also mentioned about the fee structure, and all the stakeholders were invited for a meeting, and thereafter, my lord, this consensual agreement was executed.
Or learned advocate, Mr. So and so for the. You are Mr.
Jagan Mohan.
You can Jagan Mohan for the petitioner. Learned additional government education in Farakpur for respondent number 123. And Fifth learned respondent. advocate, Mr.
I'm Krishna P. I appear for the 9th respondent.
You said Neelo Farakpur for respondent state and its authorities. Learned advocate, Mr.
Krishna
for respondent 9.
respondent.
5 million or R5 million. Respondent number 5, GS Venkat Subra. Learned advocate, Mr. Venkat Subra. R5. For respondent 5. The petitioner claims to be a public spirited person who has filed this public interest petition. This petition, the nature of public interest, seeking direction against the number 1 to 8 authorities to consider the representation dated 23/6/22 and representations dated 23/6/22 and 7/7/23. The representations are in respect to the alleged illegalities and irregularities committed by several nursing colleges and institutions in the state of Karnataka. The petitioner wants investigation by the Central Bureau of Investigation or any other agency such as Lokayukta or C or Crime Investigation Department. Petition seeks to take legal action against the institutions, including the persons and officials involved in illegalities, and further praise for refunding of the fees collected since 2009. Full stop. The petitioner has further prayed to set aside the agreement executed between Respondent 9 Respondent 9 dash the Karnataka State Association of the Management of Nursing and Allied Health Science Institution and the Higher Education Department, Government of Karnataka, dated 17/3/27, which is a consensual agreement between the Government of Karnataka and Respondent 9 relating to regulating admissions and fee structure for Bachelor of Science with BSc, Certificate of Nursing for the academic year 2024. Full stop. The averments in the petition, when carefully noticed, proceeds to give general details about the nursing colleges collecting exorbitant fees. And not providing adequate infrastructure, etc. It is the case that fees payable in BSc nursing colleges, nursing course is fixed. However, in respect of other, the fees at the wish of the institution is charged. The petitioner pleads violation of Article 21 of the Constitution in this regard, as according to petitioner, the authorities have failed to implement the norms and bylaws, norms and regulations. The averments in the petition are too general and too vague to be countenanced for any purpose, much less to exercise the public interest jurisdiction. Full stop. A petition based on omnibus averments without any specific details would hardly be entertained. The petition is not liable to be entertained. The representation of petitioner are pending. Full stop. The same may be considered, provided the petitioner furnishes specific details which may need, in the in view of, in the opinion of the competent authorities. Investigation into facts. Full stop. As far as the relief claimed in the present petition is concerned, comma, no case is made out. Full stop. The petition is dismissed.
Number 22. To Srinivas TP.
Respond number 6 in this case. For 2 weeks time to file statement of objection.
Pardon?
During for respond number 6 in this case.
Demolish the illegal construction.
Last date of hearing itself, my friend sought for adjournment for to file the.
Respond number 6, father Melody, that he's admitted to hospital. I couldn't get him for.
When will 21st, 22nd of April?
Number 23. Ramesh Nayak L, party in possession.
Lord, I'm filing my objection. This pertains to contamination of drinking water. My lord, in Tumkur, Chitradurga and Raichur. I'll file it to the office.
Filing the
Yeah.
learned additional government advocate files. It is taken on record. Copy should be given.
My lord,
You given copy to the petition.
I will see.
Copy thereof is already given. Our learned advocate petition is not present in that field. When shall we keep?
Any day, any date.
2nd April. So what you stated?
My lord, we have taken all measures, my lord, wherever, my lord, there was leakage and I have, my lord, in detail culled out, my lord, as to how the water from the dam, my lord, reaches the household and the purification that takes place, my lord, on the way.
6.
With respect to Raichur urban, my lord, that I'll have to file my objections, my lord. Bringing to my lord's notice how, my lord, we are purifying water in Raichur.
We'll
urban.
keep back. Let them go. You keep back. 24 counts. 20.
Respondent number 6 in this case.
What is it about?
That for writ of mandamus directing the response authorities to complete the retaining wall to the stormwater drainage method. Rainwater is entering into the layout method. Kindly look into the page number, lecture B, page number 45, my lord. They have also filed the written submission.
Report, my lord, as per barrister report, my lord, page number 2.
Who is there?
I'm for BBM.
BBM.
I filed the report as per barrister some court, I inspected.
Is filed. Report is filed. Reply is filed.
Report is filed.
Report is,
filed, yes.
we'll see after recess.
Okay.
After recess.
Tomorrow, my lord.
Tomorrow.
Contempt at 2:30. By tomorrow.
All right, tomorrow at 2:30.
Please.
You for it.
mention serial number 26, my lords.
My lord, this issue pertains to, my lord, to unlock the integrated lease management system so that, my lord, the petitioners could pay the royalty. My lord, a subcommittee had been formed to look into the demand notices that had been issued to the petitioners. My lord, the subcommittee has looked into it. It has submitted its report to the government on the 21st of March. My lord, the government, my lord, we need at least 2 weeks' time, my lord, to look into the report and then
This is
get
the
back
case
to my
where we had
lords.
deposited 125 crores by my lord's order. Lords, maybe taken in the towards after 3 weeks. In fact, independent of the committee's thing, we are still working out on a settlement. There are talks, my lords. Anyway, I have no objection. About 3 weeks or 4 weeks later, your lordships could have it towards the end of April, probably. By then, either the settlement will come out. There are high-level settlement talks going on.
So committee is constituted for?
Committee is constituted, my lords, to verify about our claim and the government's claim on the ratio, my lords, that's the ratio of translation between the raw material and cement that is manufactured.
On the issue of liability to pay the penalty.
Yes,
Royalty, my lord.
royalty, their demand for royalty on the conversion factor is under dispute, my lords. How much of raw material is required for manufacture of cement? That's the only issue.
Committee was already constituted.
It was, my lords. Committee, we have appeared, committee has to give its report.
It
Now it
gave
is
its
zero.
report
They say, my lords, that it's been given to the government. In
on
the meanwhile,
21st.
independent of the committee's thing, we were still holding parallelly with the, on a settlement talk also. So about 3 weeks, probably, my lords, something may.
On 29/10/24, the court had an occasion to pass the following order after hearing learned senior counsels for the respective parties. Then quote paragraph in that order. 2. To 10.2. With regard to the dispute about the quantum of penalty payable by the petitioner, quantum of royalty payable by the petitioner, as recorded in the before quoted order, for my high-level committee was constituted. The aspects which were to be gone into by the committee were mentioned in paragraph 5.1.1 of the order. Out of the total demand, the court inter-alia required the petition company to deposit 125 crores towards the claim of rupees. Out of the total claim of rupees 257.60 crores, the court required the petitioner company to deposit 125 crores. Pending decision of the committee. Full stop, paragraph. Today, when the petition came up for consideration, learned additional government advice with Nilofer stated that the committee has submitted its report on 21/3/25
And the same is pending with the state government
For approval.
for further processing and approval. In above view, the rate for time of 3 weeks to further submit that. On the next date, the court will be apprised of the recommendation of the committee and the decision taken by the state government. So, learned senior advocate Mr. Kendra for the petitioner has no objection to the time being granted to the respondents on the appropriate count. Stand over to which date? 23rd of July?
Yes, ma'am, 23rd.
Array, 23rd of April?
Yes.
23rd of April.
Obliged.
Full stop. Learned senior advocate for the petitioner also stated, irrespective of the recommendations which may be given, which may be made by the committee, the petitioner is engaged in exploring the settlement with the authorities. Stand over to.
My lords.
Interim order shall continue to operate till further orders.
My lords, if I may, serial number 70 and 71, my lords. There are two mining matters. My lords, on 12th March, we had moved an advancement application and subsequently moved a memo for the for early hearing.
Today listed?
Today, it is a date given matter. Today, it is listed. My lord, there's an urgency because the last time the matter was listed on 20th February, pursuant to which we had filed advancement, but it didn't get listed. My lord, on the last date itself, the advocate commissioner seized my assets, which are there in the mining area. My lord, if it continues like this, there'll be nothing for me to, if it kindly maybe had today, my lords, at the end of the list or after 2:30 matters, we'll be highly obliged.
Which listed today?
Yes, my lord, 70 and 71, my lords. And there are some developments also, my lords, since the last date of hearing, which we wanted to bring before this honorable court.
My lord, could it be had next week, my lord, for the simple reason, my lord, that the deputy commissioner and the deputy conservator of forests, my lord, and the petitioners, they have had, my lord, a hearing. My lord, in the hearing, an order has been passed, is what I am told, saying that these lands are not forest lands, but they are C&D lands. My lord, those orders, I do not have it in my hand. My lord.
My lords, if I may kindly, it is true, my lords. We had, there was pursuant to a letter, there was a joint meeting conducted along with the petitioner by the DC, by the forest officials and the mining department on 3rd March. Now, day before yesterday, my lords, after the meeting, there was a report. In that report, it is the same thing. Whatever they was stated in the statement of objections, they're telling the same thing, that it is an area that was given for compensatory afforestation. My lords, if my lords may recall, initially the stoppage notice was given because they alleged that it was a forest land. After all the mining approvals were given.
Keep it on first.
My lords, a little earlier, my lords, please. Anytime this week, my lords, please, my
Earlier.
lords. This week, anytime, my lords.
And the first is next week.
My lord, not first.
My lord, in the next 3 days, my lords, please.
31st.
Next 3 days, anytime, my lords.
31st.
My lord, I'll have to get instructions, my lord. I'll have to get the order from.
My lord, last time, since 4 hearings, my lord, I kindly apologize. Since 4 hearings, it's been standover. We had filed advancement. There's all my assets are being seized. I really don't know what else to do, my lords.
We'll find out something.
My lords.
Yes, but not, my
If you
lord.
need time on that day, we'll consider.
My lord, if I may say so with my lord's permission. My lord, if Eid is declared on that day, my lord, I will not do. So that's the reason.
My lords, in that case, only one request, my lords. So in that report given day before yesterday, my lords, in some of the annexures, a few pages are missing. If it is being heard in the next date, I request kindly we have a memo ready we only request those missing documents, whatever that report, be furnished to the court on the next date of hearing. If that, we believe that it solves around 85% of the problem if we can get hand of those documents. We've been asking and following up with the forest department. They have not been giving to us. So if it is being adjourned for the next date, if a direction may be passed today that on the next date, these documents which we'll be giving in a memo, if they're furnished, it'll help us, because on that day, at least they won't ask time for furnishing those documents.
10 to 7th.
Obliged.
The memos, my lord, if I may give.
All documents will be made available on that.
Please, my lords.
By the parties. Which are forming part on the report. Petition, huh? You said. Plain.
Obliged, my lords.
My lord, serial number 109, my lords. There is an office objection from council, my lord. There is in petition annexure A, we don't have original photographies, my lord. Kindly overload the 109.
This objection regarding production of original photographs is dispensed.
It is.
Lord, serial number 35, my lord.
Yes. 35.
Lord, this is the matter, my lord, pertains to DRT. Meantime, bank has also filed a writ appeal, 390 of 2025. Both the matters to be listed on 27th or 28th.
7th of
This month, my lord, 27th.
April. All right. So we'll go to 7th.
Serial 35, my lord.
30. 7th April.
Much, my lord.
The proceedings are started before the executing officer. The executing officer is proceeding with the matter. I challenge the writ order. Pursuant to the writ order, the proceedings have been initiated before the executing officer is the RERA. So the matter may be tagged and heard.
When do you want?
28 it is listed before the adjudicating officer. You may file a memo before the adjudicating officer saying the matter is pending. But any other date may be taken up at 2:30.
Which date do you want, Charlie?
Any dates.
85, 86, and 87. Stand out to
May be taken up at 2:30.
8th of 9th of April.
At 2:30.
That we'll see on that.
Good.
As requested, well.
This matter may be connected. 84, 86 and 80.
So 84 में एक line add कर दीजिए. Writ appeal number 315 of 25, writ appeal number 336 of 25 shall be listed together since they are cognate appeals.
The first over matter, serial number 19. Raghavendra G. Gayatri.
Nobody is there. Day after to go.
Serial number 23. Mr. Ramesh Nayak L, party in person. Serial number 23.
20, which is part in person. Okay, actually.
Another, in this, I have to file a report with regard to, my lord, water contamination for Raichur urban, my lord. I have referred to Tumkur, Chitradurga, and Raichur rural but only for one, my lord, the Raichur urban I haven't filed. My lord could grant me, my lord, some time, then I will file for Raichur urban also.
The 230 matters, number 112. Mr. RG Hegde, complainants. Not the complainants are before the honorable court.
Seeking for. My lords, this pertains to the caste certificate issued by the Tahsildar, my lords. Upon review, Tahsildar cancelled the caste certificate. It was held by this honorable court that such a cancellation upon review can't be made. So the earlier caste certificate was reviewed as such. So the uploading was not done with regard to the revival of the earlier caste certificate, my lords. Under section 4H of Scheduled Caste, Scheduled Tribe, OBC reservation of appointment rules, the jurisdictional deputy commissioner is the appropriate authority when it comes to cancellation of caste certificate. Upon notice issued to the complainants herein, the proceedings were conducted, and as on last Friday, that is 21st of March 2025, caste certificate has been cancelled, my lords. I shall produce a copy of the order also to the complainant here.
What is cancelled?
Caste certificate,
Cancelled.
cancelled.
No, that is not simple, my lord. My submission is this. This has arisen 23rd of April.
What was the direction to upload?
My lords,
Upload the certificate.
Upload was
Not when the direction was given, the proceedings were not pending before the deputy commissioner. Only one or two adjournments to circumvent the order of the learned single judge. They come forward with the exercise of 4F. They were given liberty on 23rd of April 2019, the first order. But I will just show how they are. What is this? This is the first order where they were given the liberty. Even though that liberty was given, they did not take any action. The complainants knocked at the doors of this honorable court repeatedly, and ultimately the learned single judge passed an order stating that this order is subject to the earlier writ petition already disposed of, where such liberty is given, provided that liberty is available as on today. Not 2019, they could have exercised that 4F power. It is not as if I have surreptitiously obtained the certificate. They themselves have granted the certificate. They did not challenge it. These things have gone before the assistant commissioner, the deputy commissioner, in various stages. Not there, the deputy commissioner, in fact, had issued us notice to appear before him on earlier occasion. That was also challenged before this court. They did not think of exercising power under section 4F. It is only when this contempt petition was filed, the earlier contempt petition came to be dropped, saying that there is no positive direction. Right? We got a positive direction. Why should they wait for such a positive direction to be given to exercise under the powers under section 4F? Normally, any order passed by the authorities, always it is parties to, but the conduct of the respondents, they did not file affidavit. They did not appear before this court, and ultimately persuaded
Deputy Commissioner to cancel our certificate. In the process, they will be circumventing the order of this Honorable Court. Whether such a thing is permissible. Now they come. Friday, they say that the parties were heard. We were not knowing about what has happened on that day. Nothing was, my instructions is, on Friday, nothing has happened. Not all of a sudden, an order is now brought, something short of antedated order. Because on that day, parties were before the Deputy Commissioner, no orders were passed. In such a situation, what is to be done? Now, uploading of the certificate is not the final one. It will not conclude the rights of the parties. Why such a thing happen? I have no quarrel regarding 4B or 4F. That will have to be exercised at a point of time. Kindly look at the order of 23rd April 2019. At the end of the order, there are 6 of the order. In the result, the impugned orders are accordingly quashed. It is needless to state that any person who is aggrieved shall be at liberty to file an appeal under Section 4B of Scheduled Castes and Scheduled Tribes Order Act 1976. Thereafter, another order came in 2022. I will show that order also. The order of the learned single judge in 2019 is reiterated. And in the operative portion, it is held. It is held. The impugned endorsements are held to be illegal only on the ground that this court, writ petition number so and so, had passed the order, reviewing the earlier order on the ground that the Tahsildar had become functus officio. In the very same order, this court at para 8 permitted any person, including first respondent, would be at liberty to file an appeal under Section 4B and F of the Act, para 8 of the second judgment. Therefore, that liberty would still operate subject to its availability at this juncture. Now, this is way back in 22nd November 22. Whether these powers could be exercised like this.
Caste certificate is issued by Tahsildar. So only the Tahsildar himself reviews the same and cancels the caste certificate. The only observation in the earlier proceedings is Tahsildar doesn't have the power to review his own caste certificate as such. But we were at liberty to approach as per the statute of Karnataka Scheduled Caste, Scheduled Tribe Appointment of Reservation rules. So the Tahsildar himself becomes the appellant. The respondents the complainant are arrayed as party. Proceedings are conducted, and thereafter the order under 4F is passed, cancelling the caste certificate as the same was obtained by providing false information, my lords. Now, page 21, para 5 of the order, which they seek implementation, may be kindly looked into, my lords. Last 3 lines, liberty as observed while disposing the earlier writ petition stands sustained even in this order as well. So when the liberty was reserved for us to approach under the relevant section, we have done so, my lords.
Challenge the certificate.
Pardon me?
You challenge this caste certificate, cancellation of caste.
Well, this is in respect of uploading the caste certificate. The earlier 2 judgments were in respect of cancellation. Not when this honorable court held that the Tahsildar had no power to cancel the certificate once he passes an order. There and then itself they have the power of exercising powers under 4B and 4F in 2019. Not the learned judge in the impugned, dated blood, he had categorically observed all the orders. That is on 29th of February 2004.
File such petition. File such petition.
This is another way of floating the orders of this honorable court. I am not disputing their power under 4B and 4B. I'm not disputing. If I remember correctly, last time this court was given to understand that they are not authorities to upload the caste certificate. They are not the authorities. That was their line of argument. Therefore, your lordship directed that some competent person, competent authority be directed or competent authority be deputed to upload the caste certificate. All these things have happened. But at the end of the day, how many times these petitioners will have to approach this honorable court for no fault of theirs?
You may be right, but we are in contempt jurisdiction. You challenge that cancellation.
Not even a paper, not even.
Why you are cancelled?
My lords,
Why you have cancelled it now? Why did you cancel the caste certificate?
because it was obtained by providing false information.
You verified it, just cancelled.
No, there was proceedings held, several hearings have happened. There's a detailed order running into 21 pages, my lord.
You got the order?
I got the order, my lords. I couldn't get it stitched because I got it at the last minute.
File it.
I'll file it, my lords. I'll serve a copy also now only. I'll file it in the registry.
My instructions are only 2 hearings have taken place. My submissions may be placed on record.
I'm giving a copy. I'll file it in the registry post stitching of the same.
I'll see memo.
Very much, my lord. I'll file it, my lords.
7th.
Due course.
When 7th, 4th, 3rd.
Third would be.
Third.
Third would be.
So 113, Mr. G.R. Mohan.
Appear for the petition.
My lord, I'm filing a memo along with the order passed by the Special Deputy Commissioner, my lord. Under section 67(2) of the Karnataka Land Revenue Act.
You copy.
My lord, I gave Mr. Mohan a copy.
Now, your lordship may kindly see. As far as the special DC is concerned, only pass an order for few survey numbers. You like. Kindly see page number 7. You like. Page 7 of the order passed by the special DC. First paragraph. The encroachment, your lordship,
To be after the case.
in the top, page 7. After applying to the NGT order, the encroachments are located adjacent to survey numbers 34, 31, 32, 24, 10 and 5 Patrapalya, Nayandalli and Davanagere, Uttaralli, Bengaluru South Taluk, so and so survey number. Based on that, notice has been issued and the order has been passed now. The order is at page number 9. The order is passed by it is page number 9. Conduct detailed survey. And now what I'm submission lordship, There is a detailed order passed by this Honorable Court on 28 July 2022, Your Lordship. Based on the volume of survey conducted by the ADLR and the Revenue Department, the measurements have been given, what are the survey numbers have given, which village also mentioned, Your Lordship, in that, and what are the various it passes through. So now only few survey numbers have been taken here and notices have been issued to some of them, Your Lordship. Not all, because may one line I will read, Your Lordship. In the 28 July order, Lordship may kindly look at 28 July, detailed order was passed based on the survey. 28 July 2022, Lordship. 28 July 2022, this Honorable Court passed an order based on the NERI report. NERI was appointed by the Honorable Court to conduct the study and submit the report. The report was submitted. Then this court directed the Revenue Department and also ADLR to conduct a joint survey. And 28 July 2022, the order came to be passed. 28, Your Lordship got it. 28 July. 28 July.
Thanks.
28/7/2022, Lordship.
You have filed.
Order of this court. Okay, all the survey numbers are mentioned in that. 28/7/2022.
Thank you.
May pass on this spot. Various survey numbers have been demarcated. 28 July 2022.
So what is to be done?
Based on that, the survey has been identified. Only in this order, only about 4 or 5 survey numbers only the special DC has looked into based on the complaint filed by BBMP. However, the order says specifically page 10, Your Lordship, to the BBMP, monitor the buffer zone regularly to prevent new encroachment, take action, conduct awareness program and educate. The ADLR is preparing a detailed study. The study is already been conducted, Your Lordship, by virtue of that order, 28 July. And direction is given to take action in terms of and 6 volumes are available, Your Lordship. It is there in the submit to this Honorable Court. 6 volumes, Your Lordship, total. So the identification is done, and part of it in that audit, this Vishwavati River Valley flows several parts in Bangalore and up to the outskirts of up to Ramnagar. So my only response submission based on that subsequent order was passed by the Honorable Court 13 November 2024, directing them to file a detailed affidavit. Affidavit has been filed. Now it has been now the direction of this court is that the DC also should look into this aspect and see that the affidavit is filed by the Deputy Commissioner. That was the order passed by 30th November 2024.
This is for the river.
Please. 13 November.
This is for the river, right? River.
Vrishabhavati Lake.
Lake.
Now may I just want to make submission. 3 days back, the submission is regarding to conduct the Kaveri Aarti. The Sankey tank is the origin of Vishwavati, which flows up to from there to the Malaysia Mill and also Basangudi. About 94 watts it passes through, Your Lordship. So the encroachments are still remaining, and the Pollution Control Board and BWSCs are filed their affidavit, Your Lordship. That the BPM has to look into it and take up the issue. That's what, because even the special DC also made it very clear. You see that no encroachments are taking place. That is the order of the special DC also. So this was mainly BBMP to look into these things and come up with the concrete thing so that the problem can be solved. Solution is there.
which is passed by the special DC, we have to work under the, as per the orders of the special DC in this.
You dispose it of.
Yes, my lords.
So this will be implementing this order.
My lords.
My lord,
This order you have, who have produced?
Government.
Will implement this order.
we have to implement.
Today, just now, we received.
Only thing timeline is not indicated.
Time limit is not,
With the court suggest.
if my lord were to suggest the time,
Survey of the buffer zone. Steps to remove the encroachments already identified. They are taking action.
28 July.
Conducting survey.
No, in this lordship, the only few survey numbers, page number, only few survey numbers, page 7. Only few survey on page 7 in that memo. Only few survey numbers, otherwise the survey report is already there and several survey numbers and what are the extent also is mentioned, your lordship, earlier 28 July 2022, your lordship. So let them examine that by the DC. That's what the your lordship said on 13th November. They should coordinate, government should coordinate with BBP and see that the encroachments are removed. That's the only thing, because it's only a few have been mentioned, now which I passed on. In fact, a needy report is available with them, your lordship. The identification, which is also part of the record, based on the 28 July 2022, the order was passed. They made a study and all suggestions are also given.
Learned additional government advocate. Yes, Tilok Akbar files memo dated 24/3/25. Along with which order passed by the Special Deputy Commissioner 2, Bengaluru South Subdivision, Bengaluru. Learned additional government advocate, Tilok Akbar produces memo dated 24/3/25, along with which produced are the copies of the order passed by the Special Deputy Commissioner 2, Bengaluru South Subdivision, Bengaluru, in respect to proceedings initiated under section 67(2) into bracket of the Karnataka Land Revenue Act 1964. Which is being done on the report dated 28/10/2011/24, submitted with the Tehsildar. In the said order, various directions are received to the Tahsildar. Correct. The said order, various directions are received to the Tahsildar as Director of Land Records, as well as to Bangalore Mahanagapalika. Before the court considers the matter further, it is appropriate to post the proceedings on 27th of March. On that day, learned additional government advocates will apprise the court about the progress of the directions. And they will take a call to complete. 28. No, April. 29th April.
2:30 your lordship. 2:30 please. Oblige. In the email, let them look into 28 July 2022 order. Specifically, it said both with the government as well as BBMP to see that it is removed.
Okay, 114.
With my lord's kind permission.
Who is that?
With my lord's permission.
Kambala matter. The Kambala matter. Yes.
My lord, earlier today, I have filed an impleading application on behalf of the former director of the Pellicula Biological Park. The application was filed only this morning, so unfortunately, it's not put up before your lordships just yet. If I may hand over copies. Impleading application. If I may just hand over copies to my lords.
But not listed today.
It's not listed because it was filed only this morning.
So what do you propose?
I'm sorry, madam.
What do you propose?
No, I have no objection if anyone wants to join and support or oppose, my lord. I have.
My submission is
From the
only this.
affidavit that they filed, it looks like they're supporting us, so I can't even oppose.
Yes, I was the founder director of this biological park until very recently. And these animals that are housed in this park have been under my care for over 21 years. I was a director and I have seen firsthand the impact that it had on the animals there. To that end, I have filed my impleading.
One submission. File in the office.
It's been filed this morning, but very
welcome.
Please.
And one more submission, my lord. The last week also, my lord, I have filed one application for impleading, my lord. There are, my lord, 2 Kambala committees, my lords. Now they are, my lord, finding it difficult to, my lord, organize. One is Bengaluru and another one is Shomogga. Shomogga Kambala committee has not been, my lord, made as a party in this writ petition, my lord.
It need not be
We
made.
have filed application that is put up, my lord, already 1/25. It's already there in the file.
We'll put up, when shall it be?
Please.
April, your lordships may consider.
April,
First
15th
week.
April. 15th April.
Wait.
I'm so obliged.
No, Impleading is there, no? No, it's there. There's no comment without permission. No, they're asking for permission.
Seal number 27. Mr. Ravindra Gajanan Pulle. 27.
Not there, then if not there, then June. 19th June. None present, 10 out to 19.
28. Mr. Pulle.
Same.
Number 29. Mr. Sridhar Prabhu.
My lord,
At 321.
Yes.
my lord, in this I have, I'm filing a memo. My lord, I'm filing a memo giving particulars, my lord, of the prosecution cases that have been withdrawn and that are pending. My lord, could I seek for some time in this matter because I'd like to argue it out, my lord?
Then argue it out.
My lord,
Annexure C is the pending cases. Annexure C, on page 17, are the cases which are yet to be withdrawn, my lords.
The placed A is what? Withdrawn.
yes,
After-
my lord.
After filing of the petition.
No, prior to.
No, prior to that, my lord. Filing of the petition only because it was not communicated, only two, my lord, cases have been withdrawn. My lord gets it at page 16. One is on 11.3 and the other one is 17.3. My lord, some time, my lord. The file was given to me just this afternoon.
Last time, my friend submitted that Advocate General is going to address the court. Now, my lords, if they are seeking time, my lord, they should undertake not to precipitate the matter. Just 21 cases are still pending, Annexure C. They cannot, my lords,
Will not
come back and.
precipitate, my lord. We will not precipitate.
No, we will not withdraw now.
No, we will not precipitate. We will not allow them to withdraw.
That may be placed on record, my lords, any date in first week, lordship may fix.
This we may take up on 3rd.
Fourth one.
3rd April.
4th or 5th.
4th.
4th or 5th.
My lord,
Third
8th or
election.
9th, my lord.
Very short point.
4th, all right. 4th. All right. 4th. Or it can be 8th also. 8th. 8th.
Obliged.
8th, it will be listed 2/3. 2/3.
The statement of learned advocate. They are not going to withdraw it now, that may be placed on
We
it.
will not precipitate, my lord.
They are saying.
Yes, madam, that may be placed because 21, half of the
I
cases
will
are gone.
produce the email, my lord, to as proof
No,
to
but
say that, my
they
lord,
should
I
not
will
say
instruct
that-
them not to precipitate.
They should not say communication is not given and all
I
those things.
will show you. Anyway, if my lord wants to record it, I have no issues.
Learned educate. Learned additional government education in local. Shall we record or your statement or we grant
My lord?
We are going to say that no further withdrawal.
Yes.
Name your in court's name.
You have instructions, right? Morning, she spoke to
My lord, I took instructions
advocate.
from the learned advocate general. He said to give an undertaking that we would not precipitate.
Yeah, next. Disappeared. Learned additional government education makes a statement that there shall be no that any of that till the next date till the next date the government will not withdraw from prosecution.
Withdraw the
No,
prosecution.
any of the cases under section 321 of the.
Great.
Oblige.
Yeah, that's 1978. Send out to third.
Number 30, to Monish Kumar KB. Number 30. Monish Kumar.
Nobody is there. You go. Delay. Somebody is there to notice it.
I appear for the respondent, my lords, only.
He is not there. 29th of April.
31 is urgent. Seal number 32, to TP Muttarna.
Next week, my lord. Next week, my lord.
Next week.
Muttani is engaged in quota number 18, my lord. Next week, my lord.
First May.
My lord. Next week is started. So, is coming,
My lord,
He is here.
in this case, my lord, this appeal has been filed only for the purpose of interest, my lord.
For the purpose of?
Interest. Not, that order has not been challenged by law. That this is a State Bank of India, they invested in because Patra in State Bank Post Office. As per the scheme, my lord, whatever invested after 8 years, 7 months, it will become double. The State Bank of Hyderabad invested from Provident Fund account 24 crores. So according to that scheme, it should become 48 crores after 8 years, 7 months. Here, my lord, then after maturity, Post Office paid only 32 crores, stating that no, we cannot pay as agreed, interest as agreed. It is only, we will give only 3.5%. Then afterwards, my lord, that the State Bank of Hyderabad, they filed a writ petition. In this writ petition, my lord, this honorable single judge ordered to pay them 48 crores. 48 crores has been paid. Now this case is, my lord, only to pay interest from the date of maturity till realization. Because the amount has been paid from the Provident Fund Trust, my lord. Complies Provident Fund Trust.
Will hear it finally. Appeal is arbitrated, which may be listed for final hearing on 25th June.
This is the plea for regularization, my lords. So we gave the endorsement that regularization cannot happen because as per clause 4 of the Umadevi judgment, the services were continued by means of the interim order obtained. So the endorsement is at Annexure A. The reasoning is also contained at Annexure A of the writ appeal as such, my lords. Now the issue is, my lords, the reasoning of the learned single judge was in the interim order in which the benefit was extended to the respondent also, it's not preferred by the respondent herein. So the issue is whether the interim order was a order in rem or in personam, my lords. So I would like to take my lordships to the interim order preferred by the association in which the benefit has also accrued to the respondent herein, my lords. Now, if my lordships were to take to page 3 to 8, my lords. Three to 5 is the cost title, my lords. The typed copy at 3 to 5, my lords.
But then Uma Devi's benefit is not required to be given.
My lord, Uma Devi, one of the contingency is they should satisfy the criteria that they were employed continuously for 10 years without the aid of the interim order. So our only reasoning given is, means in the our reasoning is because of this interim order, we continued the services of the respondent herein. Hence is not entitled for regularization as such, my lords. But we have extended the benefit of the welfare legislation of 2012, which pertains to daily wage employees. Now the issue between the state and the employee is whether he is entitled for regularization or no, my lords. Page through 3 to 5 is the petition preferred by Karnataka Casual and Daily Rated Workers Union Hubli. So page 3 to 8 is the operative portion, my lords. When, my lords, page 3 to 8, my lords. 3 to 8, my lords.
3 to
Pending disposal of the aforesaid writ petition, it is ordered by this court such and such that the termination of services of any of the daily wage employees appointed after 1/7/1984, working in various department of government establishment of Zilla Parishads and local bodies be and the same is hereby stayed. We took a policy decision that daily wage employees post 1st of July 1984 should not be continued. In pursuance of the same, this interim order was got, my lords. Our say before the learned single judge in the endorsement to uphold the endorsement, our stand before the learned single judge was, this was a judgment in rem as such, my lords. Or we had no reason to continue his services because it was the policy decision of the state as on 1990 not to continue with the services of any daily wages employee who were appointed of 1st of July 1984. The contention of the state is called out in para 5 of the judgment, my lords, which is impugned before my lordships here.
My lord, I'll make my submissions, my lord. My lord, this is my 5th round of litigation, my lord. My lord, I will just take you to the 4th, immediately the previous litigation that had been filed before this honorable court, my lord. My lord, the impugned order therein is at Annexure C, page 82. This is my 4th round, my lord, which I'm referring to at the moment. Page 82. My lord, I will take you to the relevant portion, which is at page number 85. I'll take you to page number 85 and thereafter. My lord, page number 85. My lord, the second last line in paragraph number 4. It refers to an interim order passed in WP number 8192 of 1990. My lord, why I'm referring to this, my lord? Because that is the endorsement given to me for challenging that particular endorsement, my lord, in that particular writ petition. 8192 of 1990. My lord, that particular endorsement, my lord, is at Annexure S, the typed copy and the translated copy at Annexure H. S, page number 221. My lord, the relevant page at 228. While rejecting my application therein, my representation therein, my lord, at paragraph number, at the second paragraph from the top, Karnataka State Government Daily Wages, Mahamandal, Hubli, filed in the Honorable High Court in WP number 8192 of 90. The High Court dated 11/4/1990 directed the state government not to remove from services daily wage casual workers. That is the same interim order that has been passed, my lord. And it is based on this particular order that my representation in the fourth round of litigation came to be rejected. And thereafter, my lord, the coordinate bench, my lord, the single judge, in my fourth round of litigation has passed an order which I had just referred to. My lord may turn to page number 87 now. Paragraph number 7, my lord. My lord has it? My lord, I'll read. The endorsement dated 5/12/2019 indicates that the petitioner's request for regularization is rejected solely on the ground that the petitioner would not fulfill condition number 4 laid down in Uma Devi case. Condition number 4 lays down that a person who is continued in service on daily wage basis on the strength of any interim order, such person would not be entitled for regularization. But in the instant case, the petitioner has not filed any writ petition prior to 2001. The petitioner was not continued on daily wage basis on the strength of an interim order passed in any writ petition. When the petitioner has not approached the court prior to 2001, and when the petitioner is not continued on the strength of an interim order passed in favor of the petitioner, the question of rejecting petitioner's case solely on the ground that the petitioner was continued in service on daily wage basis only on the strength of interim order passed in favor of the petitioner is baseless. Admittedly, the petitioner was not a party nor petitioner in WP number 8192 of 1990. No material is produced by the respondents to demonstrate that the petitioner was a party to the said writ petition. Hence, the impugned endorsement requires to be quashed with a direction to the respondents to reconsider the issue in accordance with law in the light of Uma Devi case, since the petitioner's case for regularization cannot be rejected on the ground that he would not fulfill condition number 4 of Uma Devi's case. My lord, this is the fourth round of litigation. My lord, the respondents have, the state, rather the petitioner herein has not challenged this order, my lord. This order has attained finality. It is subsequent to this order attaining finality that I placed a representation again before the government requesting that my services be regularized. Now, my lord, by the endorsement, what they are referring to at my annexure page, now they are producing this other order, my lord, 12166. Saying that now I'm covered by that. How can they come up with two different stands, my lord? And it is only on this aspect, my lord, that the learned single judge has passed the impugned order, that they're taking contradictory stands time and again. When that order has attained finality, saying that I'm not bound by Uma Devi's case, they have not challenged that. They are now challenging it here by citing a different writ petition. My lord, that is my only humble request over here, my lord. Every time I go for a representation, they give a different endorsement.
Consider as dismissed.
My lords, only one submission, my lords. The earlier writ petition number, writ petition was not rightly pointed out, 8192 of 1990. Now we have produced the proper order, which is 12610 of 93, my lords. Now, if my lords take at page 88, what's been referred is WP number 8192 of 1990. Now, the order, along with a statement of objections, what we have produced at annexure R6, page 325, my lords, is pertaining to writ petition number 12610 of 93, my lords. And there is, one last 30 seconds more, my lords. One last submission is, we took a policy decision to not continue any daily wage workers post the date of 1st of July, my lords. If not for the interim order, there was no reason for them to get the exemption. That's it, my lords, nothing more as such.
Even here there is.
34, 35 are urgent. Number 36 is state appeal.
Delay.
36 delay is to be controlled with respect of 102 days, my lords.
36. IN number.
I have no objection to condone the delay, my lord.
1 of 24. Applicant state has filed this application seeking condonation of delay of 102 days. Having heard learned counsel for respective parties. Pardon? And consider and having heard learned counsel for respective parties and further having considered the governments in the accompanying affidavit explaining the passage of time leading to the delay as above, could be said that since the applicant is a state, time was necessarily consumed in the administrative process before the final decision to refer the appeal could be reached. Full stop. In the aforesaid review, sufficient cause is made out. Delay of 102 days is condoned, application. What about the appeal?
My lords may set down a date, my lords will go on with the matter.
16th of April. Appeal to be listed on 16th.
Number 37. The been
Page number 399, Your Lordship. Your Lordship has already upheld. Page number 399, Your Lordship. Writ Appeal 564 of 2024.
My lord, I have a
Again,
submission.
paragraph, page number 412, paragraph number 16. In that, Your Lordship has mentioned, Your Lordship has already upheld that in a residential apartment, an association should be under the Karnataka Apartment Ownership Act. Page number 399. There are two bundles.
Page number
399.
39.
Writ Appeal number 564 of 2024.
My lord.
The last
Writ
page, Your
Appeal
Lordship.
564, there is a review petition has been filed. A notice has been served.
That is by a third party, Your Lordship, not a party to the writ petition as well as the writ
Even
appeal.
as such, he is the third party here who has come as on the appeal.
Let me complete. Your Lordship, in this case, Your Lordship has already mentioned that in a residential apartment, formation of an association should be under the Karnataka Apartment Ownership Act. Your Lordship, in this particular case, an order is passed which has been challenged before Your Lordship. Contrary to the same judgment, paragraph number, page number 38, Your Lordship, that is the impugned order. In that, liberty is given to form an association under the Cooperative Societies Act. Page number 38. That has been challenged before Your Lordship. The same court, Your Lordship, in one other case, there is an order passed totally contradictory to his observation. May I submit, Your Lordship? Okay. Because the earlier order was obtained by suppressing this writ appeal, as well as the similar orders, the court has observed that paragraph number 2, page number 3, Your Lordship. The provisions of the Karnataka Cooperative Societies Act 1959 are not applicable to the association consisting of the residential units, and therefore the association is under an obligation to file a declaration under the provisions of the Karnataka Apartment Ownership Act 1972. This has happened in the same project, Your Lordship. One group has approached, the court has mentioned that you can form under cooperative society. The other group has approached, the court has mentioned that you cannot form an association under the Karnataka Cooperative Societies Act, and you have to form under 1972, Your Lordship. So, Your Lordship, this
My lord, I have
both are totally contradictory.
on
And
this
now the
order.
court itself has
The
corrected.
judge who has passed the order, he himself cannot contradict his own order, my lord. Now,
That
a review
ground itself,
petition
the
also
first
has
order.
been filed on this. Review petition number 101 of 2025 is pending.
Your Lordship, in this case, this writ appeal order, they have not submitted before the court. They have also not submitted many of the decisions of this court, confirming that 1972 is the,
You can do it.
pardon, Your Lordship?
You can do it.
No, Your Lordship, it's an ex parte order. And here the importance, Your Lordship, the same court has passed an order contradictory to the
Their own.
first order, their own order. On that ground itself, that order will not be valid. The first order will not be valid because the second order is contradictory to the first order.
So first order will.
Probably that
second
court
order
has
will not-
realized that there are division bench orders that has not submitted before the court. And the one order which is submitted before the court is suppressing the final page, Your Lordship. They have not submitted the final page. That is also there. A lot of suppression and misleading, and finally they are obtaining these kind of orders. It is a settled position, Your Lordship. Your Lordship has also confirmed in the division bench order, and that has not submitted. And one more important thing, Your Lordship, the lawyer who has appeared in that division bench order, he was the petitioner. He was appearing for the petitioners in the other case.
The statement made by him is not acceptable because she is making an unnecessary comment, number one. Number two, sir, all these judgments, if we look at it, there is a one thing is common. WA 974 of 2019, the order passed, where the question of law has been addressed very clearly in that judgment, that order. Section 3 of the Societies Registration Act does not permit apartment maintenance. That's only the thing. However, lastly, when the petitioner as well as the respondent both are admitting to somewhere else, the court need not adjudicate on the matter and they pass an order that you go and register under 1972. Because in that where is the provision of registration under the 1972 has never been discussed at all. Even in one of the petition where recently, of course, 511, WP 511, stating their objection, they have clearly said that there is no provision to register association under 1972. Now, repeatedly, the people are being, our learned counsel is not sparing a single stone unturned to mention everywhere registration of association under 1972, where there is no provision.
Absolutely
Now,
wrong statement, Your
the
Lordship. Section
question comes
30.
here is that we should read, what is page number?
Section 13 of the Karnataka Apartment Ownership Act prescribes the procedure, Your Lordship. A
Section 13
declaration
talks
has
about
to
the
be,
registration of documents. Please
declaration,
don't try to mislead the court. Sir, here in the writ, this appeal, page number 4152423 is the writ appeal, writ appeal of 974 of 2019. Now, let's see what is the paragraph number 11 speaks of. As observed by the learned single judge, the impugned order as well as this order will not prevent the persons who are members of the appellant association from taking steps for formation and registration of an association of condominium under the provision of the said 1972. They are giving an option for them to do it. It's not compulsory that they should go about. As such, Karnataka Apartment Ownership Act itself is an optional one.
Order was passed, similar matter.
Another thing I would like to put to you, my lord.
Your Lordship, one order.
1 minute, let me put it. See here, there is another case is also being listed today, my lord.
Your Lordship, there are similar cases passed last week also.
Yes.
There is an order passed in the similar line. Your
All are depending on WA 564.
Based on the division bench order, there are
It is under review now.
plenty of decisions.
We are enjoying some relief.
Your Lordship, yes, Your Lordship, last week, there is a decision from the court. There are plenty of orders based on Writ Appeal 974, as well as the cases which is referred in Writ Appeal 974. Not only 564 also, Your Lordship. 564 is Your Lordship's decision. In that, many cases were referred. Based on that, last week also there were decisions. Because in 399, Your Lordship, if Your Lordship goes through page number 399.
Most of these cases have been referred 564.
Page number 3.
Advantage. My lord, here I would like to put
only one submission, Your Lordship.
like to make one submission, my lord. Under there is another petition is also pending listed today. Probably it may not list. Serial number 74. The petitioner in that appellant in that case is very clear. Under the 1972, it is not a body juristic, and he cannot able to maintain it. So if you club both the things and here, that will be a better option, my lord.
March, April.
Pardon, Your Lordship.
Third April.
My suggestion is that, my lord, this case as well as 74, if you club it and here, that will solve all the problem. That is one. And secondly, where many people are commenting on this, that is a registration of a document which is without authority of law that is taking place is also under challenge. Today it is also listed. So if we can able to hear, the entire thing will be clear, my.
Your Lordship, the Act has prescribed 2 steps. One is that you have to execute a declaration, that too before the registrar. So if the act has mentioned certain things, it has to be followed in that way. So all the apartment owners association, they have registered the declaration before the sub-registrar. According to them, that is not a registration because the act has mentioned a competent authority to implementation of the act, for the implementation of the act. So according to them, we have to go and register
There
before
is
the
no such
Cooperative
provision.
Societies Act for the property.
Competent
That is
authority has
absolutely
been given
wrong,
to
Your
any
Lordship.
authority under the act. It is wrongly being
CRP
submitted.
96 bar
It is
2020.
wrongly being submitted under the competent authority defined under Karnataka Apartment Ownership Act.
My
No
friend has to
authority
look
has
into
been
the
given to
definition
him.
of competent
Other
authority.
than just somebody has to go and submit the paper. There ends the matter.
CRP 96, it is very clearly mentioned, Your Lordship. What are the steps required for that? Declaration,
Even CRP
registration.
96 also says that association to be registered. Now, where is the registration? Now, say when in fact the other petitioner, they are claiming that I'm not a registered body under this, I can't able to function because as a association of apartment owners, there's a lot of contracts we have to deal with. And without a registration, it will not work. And state is very clear under the Karnataka Apartment Ownership Act, there is no provision to register an association.
The statute is enacted in 1972. After 53 years, they are saying that the procedure is
The
not right
basic
and cancel all the associations who are as registered till date.
Basically, it's a wrong perception that my learned counsel is having. The purpose of the Apartment Ownership Act is to provide independent, heritable and transferable to a portion of the building. It is a addition to the Transfer of Property Act. It should be read along with the Transfer of Property Act, not independently.
Yes, Mr. Chandra. You have to contribute some. Third. You can contribute.
Interstate dispute.
Interstate. What is that?
No, what the state has given in objection in 511, they made it very clear in paragraph 19 and 20 makes it very clear that it do not constitute any association or there is a provision and it is wrongly promoted by the people.
He is talking about a decision upheld by this court, Your Lordship. The court has very clearly, division bench has very clearly mentioned, you have to form because it is a specific statute.
There is no provision to register an association, state is very clear.
Section 16, if my learned friend has gone through, then he can understand
If,
that there are
basically
provisions
the
for that.
problem with most of the people is apartment ownership comes with a dual ownership, they do not understand.
Right. Today is 3rd April. Today is 3rd April. Today which date? Today is 3rd April.
No.
Then they kept it in 3rd April.
Third April.
Much of that.
Even,
Number
my
38.
lord, even 74 also can be clubbed with the serial number 70.
Number 38.
Serial number 38, I appear on behalf of the advocate for the petitioners.
I'm appearing for respondent number 1, ma'am. Kindly have it on day after tomorrow, ma'am. Council is not in station.
Well, and also the respondent number 2 had been directed orally on the last occasion to indicate that the seat has not been filled up. Matter, my lord, this was relating to physically handicapped persons. I am currently working in BESCOM in the physically handicapped category.
Which is
There was a
post assistant accounts officer. Yes, what is wrong in it?
My lord, there
Yes.
is, my lord, there are no other candidates available. I meet the merits, the qualification criteria required for physically handicapped. There are no reasons assigned by them why they're not selecting me. In fact, I have been mentioned in the provisional list also. Provisional list, my lord, will see at ink page 73, my name appears there. My lord will give me a minute. My lord, at ink page 83, ink page 83,
Hmm.
in the shortlist candidates, my name is mentioned at serial number 185.
Hmm.
At ink page 89, when they announce the provisional list, my name is missing. Yes. My lord, compare page 83 with page 89. Page 83, item number 185, I have been shortlisted. I meet the cutoff requirement also. I meet the handicap criteria also at page 83. Now, my lord, at page 89, where the provisional selection list is announced, at serial number 25, page number 89, my lord, serial number 25, page 89, serial number 25. Eligible candidate not available. There is no reasoning provided for this. In fact, my lord, I'll also be pressing into service the recent decision of the Supreme Court in visually impaired for judicial service case, where the Honorable Supreme Court has said that if physically handicapped candidates are not eligibly available, then the next available candidate should be accommodated.
So what are you showing?
The order, I'll just take my notes of the order.
You're showing page 87. Your name
Yes, my
is
lord.
at page serial number 25. So what are you showing?
Lord, at page 89, serial number 25, page 89, serial number 25, what I'm showing is at page 83, my name was there in the provisional list. But when they announce the selection list on page 89 at serial number 25, they say eligible candidate not available. My name is missing. Pages 83 and 89 to be compared. For this, they needed to explain.
Kindly have it on day after tomorrow. Kindly have it on day after tomorrow.
Why?
Senior is not in station, that's why.
Matter is over, then your request. So, Mr. Joshi, what are you saying then? What?
My lord?
What is your submission?
No, my submission is this, that there is no reason for them to have disqualified me. And if there are no other eligible candidates available, the Honorable Supreme Court, my lord, I am handicapped today, unfortunately. I am not able to remain physically present. Otherwise, I will be pressing into service the recent decision of the Honorable Supreme Court in the case of employing visually impaired persons in judicial services, where the Honorable Supreme Court says that at the end of the day, if eligible candidates are not available as per the predetermined criteria, the criteria should be relaxed so as to accommodate the next available physically handicapped person, which I am available, my lord. I am not eligible.
First, let us understand the controversy, then citation. What is the controversy?
It's tomorrow, my lord. Tomorrow. Tomorrow.
Why? What is the controversy?
Yes, ma'am.
What is the controversy?
The appointment of disability person appointment.
You started
Physical-
practice from this matter, you starting.
This one.
Starting your practice from this matter. Since how long you are practicing?
3 years, my lord.
Since how long you are practicing?
3 years, my lord.
3 years.
And trial court practice, no, that's all. Trial court practicing.
Trial court practice better than high court practice.
Just gave file this.
Trial court when there is no controversy. Judge doesn't ask about the controversy in trial. No, you argue, but actually. So much time you have invested without speaking anything. Now start speaking.
No, file just given, my lord, that's why.
Pardon? Senior is in difficulty. Senior is in difficulty?
Yes, senior not in station, that's.
Not in station. So therefore you are here. You are in station.
Yes.
Station properly. You are in station properly to argue. We'll sit here till you argue today. Even it is 5, 6, 7. 5 o'clock, 6 o'clock, 7 o'clock. Till you start arguing, we will sit.
At least tomorrow.
Till tomorrow we can't sit. Is this the way to project yourself? Same position.
Senior counsel is appearing for me. Senior counsel is appearing for me.
Senior counsel, we like to listen only physical argument.
Well, I would have been present physically, my lord. I'm aware of that. Today, some difficulty I got head up.
Four.
Grateful, my lord.
So number 39. Chand Pasha.
I appear for the appellants. I seek for a short accommodation.
I request, my lord,
In the next week at your lordship convenience.
request, my lord, the demand notice was raised for an advertisement which they put up, my lord, on the underpasses in Bangalore city. My lord, a demand notice was raised and that was challenged before the single judge, my lord. Single judge, my lord, had only told us to consider the representation with the show cause notice which was issued with a deposit of 6 crores. That, my lord, has stayed that part of it, my lord, was 6 crores, which is the admitted amount, my lord. Kindly see, my lord, kindly before the single judge, my lord, kindly see page 82, my lord, the demand notice, my lord.
Who appears for appellant?
We appear for the appellants. Senior counsel is engaged in this matter. Senior counsel is engaged in this matter. I seek for a short accommodation. Any date at your lordship commence in the next week.
Nawaz Sharif appears in this.
Myself.
Nawaz Sharif.
It's myself. I am Nawaz.
Nawaz Sharif.
Yes.
A great name.
Yes. Great fellow. We have engaged the services of senior.
Started practicing
Yes, your lordship.
instead of. Who is Nawaz Sharif?
He was ex-Prime Minister of
Yourself?
Pakistan. I'm here.
Person now. You don't want to argue again. Today nobody
Thank-
wants to argue. All
We
right.
have engaged the services of senior counselors.
The senior is not there. That's a good time to argue. Senior is not.
I request for a shorter date.
Interim order may kindly be extended.
No, interim order is not.
My lord, the interim order may kindly be extended. Any specific date in the next week at your lordship convenience? Because senior counsel is held up in this general body.
Your name is Nawaz Sharif.
Yes, Your Lordship.
We are not arguing. Then how can we extend the interim?
Humble submission, Your Lordship.
We are also humbly saying no. Tell you.
But interim order may kindly be extended, Your Lordship.
No.
It may be passed over, Your Lordship.
No, nothing going, nothing going. When shall we keep?
Any date in the next week, Your Lordship, at your lordship convenience. We'll argue on the matter. We'll argue on the matter any date in the next week.
Next week.
Lord,
7th of-
humble request, my lord. Interim order may kindly be extended.
That will not.
Because similar orders have been passed by the coordinate benches where the demand notice have been stayed, Your Lordship. In this particular matter, the demand notice was directed to be considered as show cause notice and deposit of 6 crores had to be made. On previous occasion, the Lordship has perused the coordinate bench orders, Your Lordship.
Today we will not interim, extend the interim.
And the direction is to deposit 6 crores. We have sought for stay. On the previous occasion, the Lordship has stayed the order. Obliged.
Vital BR.
Send out to 7th April, interim order shall stand extended till next.
My lord, Vital BR is admitted in the hospital. Our 511 counsel.
Now, sir.
I'm the petitioner in that case.
Your lordship's heard.
And also I'm a respondent advocate in 40.2. IA1 and IA2.
We overheard what was submitted in serial number 37, but the submission that the state has actually distanced itself from the 1972 Act is totally wrong. The state has actually said that 1972 Act is perfectly in accordance with law. We're following the procedures. Kindly see the statement of objection. I wasn't following, to be honest, but I just overheard.
This is coming for the first time, probably.
Your Lordship, I have made three applications for impleading. May be allowed. IA 2, 3, and 4 of 2020.
We are representing
In IA
5,
IA
6, and 8, Your Lordship.
In case of 40.2, I'm the IA1 and IA2 of 24.
Direction to amend the registration act in order to give effect to the Karnataka Apartment of One. We can't amend registration act. Absolutely legislative. Very prayer cannot be granted. Nothing more is required.
The whole prayer, Your Lordship, there is no book. So that the entire statute has to be invalid. Declare it as null and void. So if there is no book, the court can give a direction to keep a book.
Basically, the Karnataka Apartment Ownership Act
You are
is a
repeatedly
facility
saying
that has been.
misleading. Please tell what exactly I have
Yeah,
misled.
I'll come to the misleading. There is no provision to register an association, hence it is misleading.
Section 13
When
gives
section
an answer
13
to
talks
that.
about registration of a
Very clearly
document.
mentioned, Your Lord. Sorry, Your Lord. Sorry. Sorry.
No, that's why.
My lord, any document registered under the Registration Act 1908 is a document that gets registered, not an association.
So what is this for? Let us see.
Your Lordship, in this, I have a submission differently from the others. Your Lordship, my submission is, my Lord, after the RERA has been enforced by the
Your
Parliament.
submission will consider the year for impleading part.
Yes, my Lord.
What is the subject matter?
The subject matter is
Yes,
sub-registrar is registering a document for which he is not empowered.
he is not empowered.
No. The RTA reply provided by them itself says that there is no provision to register and the cost what they are collecting, there is no provision even in the stamp act to collect the said fees. So the registration by the sub-registrar is unconstitutional.
Of registration of what?
The said document, the deed of declaration.
We had submitted some case laws, Your Lordship, already. In that CRP 96/2021 is also there, where the court has verbatim compared this provisions and in that mentioned that section 13, it is before the property registrar, sub-registrar. I can also read the provisions of section 13. Section 13 prescribes the provisions under which a 1972 association, how it can be formed. With your Lordship's permission, I can read that. Declarations, deeds of apartments, and copies of floor plans to be registered. We have it. Section 13, Your Lordship. 13. Karnataka Apartment Ownership Act, Section 13. The declaration and all amendments thereto, and the deed of apartment in respect of each apartment and the floor plans of the buildings referred to in subsection 2 shall be registered under the Registration Act 1902. Then subclause 3. In all registration offices, a book called Register of Declarations and Deed of Apartments under the Karnataka Apartment Ownership Act and index relating thereto shall be kept. The book and the index shall be kept in such form and shall contain such particulars as may be prescribed. And subclause 4, it shall be the duty of every manager or board of managers to send to the sub-registrar of the sub-district in which the property containing the apartment is situate, or if there is no sub-registrar for the area, to the registrar of the district in which such property is situate, a certified copy of the declaration and deed of apartment made in respect of every apartment contained in the building forming part of the property, together with a memorandum containing such particulars as may be prescribed. Then clause number 5 says that the sub-registrar, or as the case may be, the registrar shall register the declaration along with floor plans, the building and the deed of apartment in the register of declarations and deeds of apartments. So as per this provision, it is a sub-registrar's duty to register the declaration. And subclause 6 says that except as provided in this section, the provisions of the Registration Act 1908 shall mutatis mutandis apply to the registration of such declarations and deeds of apartments, and the words and expressions used in this section but not defined in this act shall have the meanings assigned to them in the Registration Act 1908. Then if your Lordship, we can go, in case if we can go to CRP 96/2021. I have submitted the case laws, Your Lordship.
But in this act, there is the association.
Read these together, section 13 plus CRP 96/2021. The provision is very clear, Your Lordship. Your Lordship has summarized all these things in paragraph number 23. There are 5 questions raised in this particular case, and finally a summary is given. Last posting date. 2 sets of books.
My humble submission is.
We have separate bundles.
My humble submission is.
Excuse me, can I submit? I have extra copies. Page number. Sorry. Page number 62, Your Lordship. of the case bundle. Page number 50, pardon, page number 62,
Yes.
paragraph number 23.
Hmm.
KOA, to summarize, KOA would only apply to an apartment where it is used for residential purposes. A
No, no.
flat,
Yes.
a flat or an apartment which is used for an office or showroom or shop or godown cannot be subjected to KOA and would always continue to be governed by KOFA. KOA is Karnataka Apartment Ownership Act, Your Lordship. So when an apartment is proposed to be constructed or under construction and agreements are entered into, KOFA would apply insofar as the relationship and or dispute between the purchaser and promoter. KOFA is a statute which prescribes the obligation, certain obligations to the promoter, the builder. He has to follow certain responsibilities that is mentioned in Karnataka Ownership Flats Regulation Act. KOFA would continue to apply if the apartment is not subjected to Apartment Ownership Act as afore detailed. Once an apartment is subjected to KOA, KOFA would cease to apply, and it is only the KOA declaration, deed of apartment and bylaws which would be applicable. In the event if an apartment being removed from the provisions of Karnataka Apartment Ownership Act, in terms of section 14 of KOA, KOFA would come into operation. Essentially, Your Lordship, next para, 23.6. Essentially, KOA, declaration, deed of apartment, and bylaws would be the provisions under which the relationship between an apartment owner and association of the apartment building property which would be governed. Once the property is subjected under the Karnataka Apartment Ownership Act, it is a declaration, Your Lordship, deed of apartments and bylaws would be the provisions, Your Lordship. KOFA would apply insofar as the relationship and or dispute between the purchaser of an apartment and promoter and any defaults on part of the promoter. The other enactment like RERA would also be applicable. Even when an apartment is not subjected to KOA and KOFA applies, the dispute and the relationship between the apartment owner and the association would be governed in terms of the rules and regulations under the cooperative society under which the said association is registered, or the term. This is this particular point is talking about in case if there are commercial apartment units, Your Lordship. Next point is 23.9. If the association is formed under KOFA, registration of the association would be required under the Karnataka Cooperative Societies Registration Act or the Companies Act, depending on whether it is a cooperative society or a company which is to be registered. In the event of a declaration, deed of apartment and bylaws being executed and the apartment building property is subjected to KOA, the said documents would have to be registered before the jurisdictional sub-registrar, Your Lordship, and the same be informed to the registrar of the Cooperative Societies Act, because it is very clearly mentioned that the authority under which the declaration has to be registered is the societies, is not the society's registrar, it is the property registrar, jurisdictional sub-registrar. There would be no requirement for registration of the declaration, deed of apartment or bylaws with the registrar of the cooperative societies. See, all these points are related to the residential apartment, Your Lordship. If there is a commercial units, then it can be registered as a company or as a cooperative society. But when there are residential apartment units, there is a specific statute, that is Karnataka Apartment Ownership Act.
They are saying they're not registrable.
Their argument is that it has to be registered under Cooperative Societies Act or as a company or whatever it is in a residential apartment. The case law which I had pointed out before also in a residential apartment.
My lord, KOA deals apartment as a property. It do not talk anywhere about the association. There is not a single word about the association except under the definition column, where the definition says that all owners acting as a group is association.
Yes, Your Lordship.
Now, the question comes, what is property? It is defined under section 3Q of the Act, where it says the title, the entire land on which the building or the project is constructed. Then what is apartment? Now, if we go to the definition of apartment, it gives the essence of living space. Now, the living space is not transferable, heritable in any manner. So, to give an effect of Transfer of Property Act to the apartment, a Karnataka Apartment Ownership Act is enacted. Now, here, apartment always comes with the dual ownership. What is that? One is owning the apartment, that is what we call it a living space. And another one is a property. Property has to be co-owned. Collective ownership is necessary. Now, when a collective ownership is not achieved, RERA as well as other enactment mandates the owner of the property is only liable to maintain. Now, only once the property is conveyed, the said thing will fall under the Karnataka Apartment Ownership Act. Sir, to give proper effect to this, State of Karnataka in the year 2004 has issued a circular. Even the cooperative society who has taken a conveyance shall submit the deed of declaration and submit the copy to the Register of Cooperative Society. I'll provide the copy in my next meeting, and it is available in the book. One can see here the page number. Yeah. HSGH HS 160 of 2003 and 2004, dated 7/1/2004. And the state government has already given a clearance to this. To give proper effect under the Cooperative Society Act also, Section 38 of the Cooperative Society Act has been amended. There has been provided a facility that it is not the property of a cooperative society, but every such transfer has to be registered. Cooperative Society Act, absolutely, there is no, the only here by forming a body corporate.
All these posting days,
By forming a body corporate, the property will be collectively held. I don't say it's a cooperative society. Either it may be a company or a cooperative society, or to own a property, the association of apartment owners essentially requires to be a body corporate because they are owning the immovable property. Now now everybody is coming and jumping into this. This is a very simple. This one we are asking the state government to follow the law. That is, if they don't have a facility, they should not register it. Now, why special book? The Act mandates special book. We need to understand this concept in a very broad manner.
Your Lordship, my only submission is that the Act provides for registration. And all these posting dates, he was saying that there is no provision for registration. I was trying to point out Section 13. Section 13 very clearly mentions that it has to be registered before the sub-registrar. In CRP 96 also, the court has also confirmed that it has to be registered before the jurisdictional sub-registrar because it is related to the property. There is a principle behind that. And an implementing authority is decided as a cooperative society's registrar. In case if there is any dispute, we can approach the cooperative society's registrar. That
The
is the
court
way
has
it is.
declared so far that
Your
deed of
Lordship,
declaration is the
but
association registration, my
Section
lord.
16 again mentioned that how to constitute an association. Section 16 says that along with the declaration, you have to submit the bylaw of maintaining and managing the property.
Section
So Section
11.2 makes
16
it very
bylaws
clear.
and
A
their
true
content.
copy has to be enclosed.
Please let
There
me
is no true
submit it.
copy.
I didn't object you. Section 16, it is clearly mentioned, Your Lordship, bylaws and their contents. The administration of every property shall be governed by bylaws, a true copy of which shall be annexed to the declaration. Along with the declaration, when we register before the jurisdictional sub-registrar, Your Lordship, the bylaw also has to be submitted. So, and this bylaw should also be registered. No modification of or amendment to the bylaw shall be valid unless set forth in an amendment to the declaration. And again, Your Lordship, the content of the bylaw is also mentioned in section 16 subclause 2. So the act is complete in every sense, Your Lordship. Where to do the registration is mentioned. How to do the registration is mentioned. What are the contents of the declaration? What are the contents of the bylaw? Only thing is that sub-register officers are not keeping a book. In a similar case, in a different state, when this question pops up, the court said the government can give a book to the sub-registrar, the issue itself will be resolved. And only on that basis, a statute cannot be declared as null and void. In 1972, now we are in 2025, Your Lordship, thousands of associations are formed in big buildings.
There are number of
And a
judgments.
lot of money is there in their account. They are maintaining and managing the property very well. In one project, which I have submitted around 700 units, Your Lordship, where I'm representing number
In a
6.
parametria cases, that is in Maharashtra, it has been held that such a document cannot be registered in tits and bits. The implementation has to be in total. I'll provide the copies. Very recently, I think 2022, the Bombay High Court has given the judgment. And another one, landmark judgment, Paul Purambi versus Bombay Dye, is very clear. Even during that period, the court has advised them to register a cooperative society for the ownership. And rightly in one of the things I have put Almeda versus CSI society, where it makes, if the cooperative society is not formed, the property right of the apartment is frustrated.
Register of declarations in of the award and index relating to shall be kept.
Yes.
However, what is
It is only a document, nothing. It's not association.
Which?
now any relief even if you are right in some way, we do not know, but then granting of relief, we have to amend the Registration Act.
If the declaration, if your lordships go through, the sub-registrar seal and signature, everything.
My
is
lord,
there.
it is like this. This act is good. I don't dispute on that. It should be implemented in true spirit, but not in tits and bits. And thirdly, this registration of the document deed of declaration, which declares the portion as an immovable property, has been dealt as an association formation here. It is not the fact. And today, after the enactment of RERA, the matter is very clear. The builder, the promoter is liable to convey the title to the organization of allottees. Now, if they take it in that sense, the builder in Karnataka will never convey the title. In fact, the CRP 96, 23.4, yeah, 1 minute.
The builder in Karnataka is the only one who is transferring the title, your lordship.
So far,
That is
if
the
they
reality.
get it, please let me provide one copy. Having transferred to the apartment owners collectively, I will drop all the things. So far, many builders, in fact, after submitting to the provision of KOA, they have bifurcated the title, khata. And they have mortgaged the property and taken a loan on it. And there are some people, we have not sold. Who decides UDS? Nobody is there. He only decides. If a FAR is 2.5, if the construction is say 250 apartment, that means that 250 apartment, it should be distributed. But it do not happen. After a few years, they construct another building in the Bangalore.
Where it's registered.
Lordship,
RERA rule requires registration.
It is repeatedly the things have been, nobody. Number of cases I can give, my lord, here.
Lordship, my one humble submission, Your Lordship, as an impleading applicant, I am before Your Lordship is because after the implementation of RERA, the RERA is implemented under, my lord, the third list, where the Karnataka Apartment Ownership also Act is also repealed. There is a repugnance. It is unconstitutional to enforce Karnataka Apartment Ownership Act, where the RERA has to be enforced. I'm the cooperative society which has been formed for enforcing the, to avail my rights under RERA. If 1972 Act is enforced, I become a nullity and all my rights under the RERA will be.
It's about registration of a document before sub-registration.
No, it's a PIL, my lord. It's a PIL where the validity of 1972.
That makes it
is also
even more
located.
dubious, my lord. Now, that's why I'm glad my learned friend said, in the guise of a PIL, my lord, basically these societies are espousing their cause. I don't think this, at the threshold itself, there is a
Wrong registration is leading towards a mass problem here.
It is a deemed repealed act, my lord.
Tomorrow again will come.
Obliged.
Same thing. And
My
put an
lord,
end.
2:30.
Serial number number 55, contempt matter, my lord, and for the accused is also present. I have filed my Palatnama today morning. I pray for 2 weeks' time to file my objections.
2 weeks.
Serial number 100, my lords. Serial number 100, let a date be given, my lords. Serial number 100, contempt petition. Serial number 100.
Yes.
Let a date, yeah, I can make,
Date will be given.
yes, my lords.
Date will-
Lord, serial number 65 and 99, my lord, to be heard on the same day, my lord. Both are connected matters, my lord.
Serial number 108, my lords. My lords, a request for a short date is a moved matter, my lords. The petitioner is a medical student, my lords, who is physically handicapped. My lords, all that he is seeking is for the assistance of a scribe, my lords, to write his exam again.
It's
My
an appeal.
lords, scribe, my lords.
It's an appeal.
Pleased, my lords, a writ appeal. My lords, a single judge, my lords, the learned single judge, without considering, my lord, prior C of the petitioner, my lords, had rejected the petition. My lords, a
Day
short,
after. Day after.
please, my lords. My lords, a short date may be given, my lords.
Day after
Matter.
tomorrow.
Please.
Day after tomorrow.
My lord, serial number 41, your lordship. 41. My lord. Any date in the next week? My lord, serial 41, we have filed application for bring the LRs on record.
Date will be given by court.